Here we go.
Good morning, everyone. Welcome to the Joint Standing Committee on Veterans and Legal Affairs. Happy Monday. I hope everyone endured the interesting weather we had last night. My name is Craig Hickman. I represent Senate District 14, which are the towns of Pittston, Chelsea, and Randolph, Gardner, West Gardner, and Monmouth, Hollowell, Farmingdale, and Manchester, Reedfield, and my hometown of Winthrop. This morning, we have 3 work sessions. We have some language reviews and discussion, and we have a confirmation hearing at 1:30. So with a full day, it'll be nice and busy. I love taking votes. Hope we can vote on as many things as possible today. And before we begin our work, I'll start with committee introductions. Senator Farron.
Good morning, Mr. Chair. My name is Brad Farron. I live in Norridge Walk, and I have the distinct privilege of representing the majority of Somerset County and the town of Rome in Kennebec County.
Representative Supika. You're on mute.
Sorry, I have too many screens going on right now. Good morning, I'm Representative Laura Supika, and I represent District 126, the portion of Bangor.
Representative Wood.
Good morning, I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Riley.
I'm Representative Riley. I represent House District 34, which is part of Westbrook.
Representative Kinney.
Good morning, I'm Marianne Kinney. I represent House District 99, 9 towns in Western Waldo County.
Representative McCray.
Good morning, I'm Jay McCray, representing Harpswell, West Bath, and Northeast Brunswick in the House.
And Chair Chiazzo.
Good morning, everybody. Chris Chiazzo, House District 28, beautiful West Scarborough.
Great, and we also have with us our awesome analyst, Janet Stocco, and our wonderful committee clerk, Karen Montel, who will help with any technical issues anyone has. But since today is a work session only, we probably won't have too many people from the public weighing in the morning. So we have 3 LDs to work: LD 1750, 1906, and 1643, and we're actually going to go in that order. I know that Chairman Chiazzo has a few things to say about LD 1750. So with that, I'm going to open up the work session on LD 1750 and act to create a framework for Maine Spirits contract, and ask Chairman Chiazzo to give us an update on where we are.
Thank you, Mr. Chairman. So we're very, very close to pulling this over the finish line. We just had some language that Babilo, the department, has suggested via the procurement team. So that arrived this morning, just minutes ago, if you will. So we need to kind of look at that, coalesce that. I need to get with Janet and meld that in and make sure that it gets us where we need to be before I present it back to the group for a vote. So probably not ready to vote that today because we need to finalize that and make sure that the language lines up with the intentions and the expectations. But I did want to kind of set the table a little bit and just say, remind everybody, this really isn't the RFP. This is really authorizing the department to engage in the RFP process. So it's going to be it's going to be the 50,000-foot view, hopefully, and not down into the weeds too much. So with that, I'm happy to, we can continue discussions if you'd like, if there are questions or concerns based on the information we have to date in terms of what's proposed, what's not proposed. Certainly can take that up, but I think we'll need just to probably, I think maybe another hour or 2 with Janet and I just going through and cleaning it up and having a final product ready to present to the committee.
Thank you, Representative Chiazzo. Are there any questions for the House Chair? Seeing none. So we did yesterday or the day before receive a memorandum from Christine Cummings, who represents some of our retailers. Did everyone receive that? Okay, so Janet is shaking her head, and what I am going to do, if someone has their email open and can forward that document to Janet, it would be great. Can someone do that, since my computers are not cooperating with me?
I've got it up, Senator.
Thank you, Representative Kinney. If you could share that with, I'm also going to promote Christine Cummings to a panelist so that she can walk us through the document that Janet will be able to share on her screen when she receives it from Representative Kinney. So it just take us all a few minutes to get set with that. And in the meantime, I will ask Christine Cummings, good morning, to introduce herself, who she represents, and then we can listen to her and ask questions if we need to. The Zoom is yours.
Thank you so much, Senator. Christine Cummings with the Maine Grocers and Food Producers Association. Thank you for the time this morning. Really appreciate it. Just wanted to provide a bit of a background as to where we came with our legislative recommendations during the first public hearing. We had been working very closely with Senator Lucchini since August of 2021 with a subcommittee. Our subcommittee represents over 100 licensed agency stores, including independent stores and supermarkets. And we really spent a good majority of the end of last year working with stakeholders, our members, agency stores specifically, and also members of the administration and the Bureau, and tried to bring forward a cohesive turnkey plan, remain as transparent as possible. And so we're equally intrigued to learn more as to what DAFs may have brought forward along with the Bureau for some recommendations. We have reached out and, we would very much so value the opportunity to continue that transparency. We know this is a 10-year deal, and it's very important that it's done right, as the retail partners are the state's fully vested partners, doing everything from stocking shelves, inventory management, age verification, intoxication screening, and really maintaining that product is displayed well and always stocked on those store shelves. So our ask is, again, the 20% discount margin as the statutory floor. That is our one ask that is in statute for the next 10 years. And we really are making this ask on behalf of our agency store partners who, after having many conversations with them, they need to average about 24 to 26% margin to sustain their business. So a 20% discount margin on spirits is really simply asking to keep pace with the price of other goods and other costs. And so, as you know, I'm sure many of you have heard from your members or constituents as well, payroll costs have been up. I just got a phone call and an email last week from one small store in Northern Maine. His electricity bill is more than $5,000 this past month. And so, and those calls are common. I received another one most recently over the weekend as well, just asking, what type of relief is available. And so, again, if there's one opportunity to put something in statute for these retail partners, that 20% discount margin is a primary ask. And in addition, the primary ask is an attempt to continue to share the growth with the state. We're certainly not looking to take any more than what we've been allotted in the past. It's really just continuing to share that pie as it grows. And so I wanted to provide that point of clarity, and happy to answer any questions as you folks navigate this issue.
Thank you, Christine, for being here this morning. Janet, did you receive the email from Representative Kinney? I know you've already talked about this, Christine, but I just want for folks who may need a refresher and who are watching today, since we are not in committee room and cannot hand out sheets of paper. This basically is the ask of the Maine Grocers and Food Producers Association. And Janet, if you could just scroll down a little bit. I think, Christine, if you could go back to just talking about keeping pace with increasing operating costs, this section of your memorandum, I think.
Yes. So as I mentioned, after having conversations with many different store sizes, whether it's independent stores, supermarket chains, we certainly value the business model itself, but costs continue to increase across the entire board, payroll, workers' comp, insurance, healthcare. It's just all continuing to rise. And having a conversation with one of my board members last week, they have a single staffer dedicated to just price increases and making those changes on the storefront. And so a 20% discount really helps put spirits in line with almost in line with, the beer and wine category. Other grocery store items are gleaning about 20 to 30% margin. And so our ask is just to simply put this product category in line to help our stores keep pace with the current cost of doing business.
Thank you. Are there any questions for Ms. Cummings from the committee at this time? Chairman Chiazzo has his hand raised.
Thank you, Mr. Chair, and thank you, Ms. Cummings, for walking us through that. Janet, if you can just take it down so I can see faces, that would be great. Thanks. Thank you. So I fully appreciate the role the grocers are playing, and we have taken some of the recommendations under advisement from the original proposal. I guess my challenge, if you will, and it's not really a challenge, I just kind of get a little more clarity. Where does the 24 to 26% operating margin come from? That seems pretty high for a business. I'm just curious to know where that is, and in essence, are you asking for the spirits contract to help subsidize that? Because I'm not sure if the overhead costs are tied directly as they would be for some of the other products. So maybe you can explain that to me a little bit. How do those operating costs directly compare to the spirits versus some of your other products?
Sure. Thank you for the ask, Representative. That was certainly something that I was looking to gather more information from coming into the discussion this morning. And so again, we're really looking to just have this product category, the margin, keep pace with the cost of doing business and align it with other categories. And so whether that is similarly to the 18 to 20% that beer is currently receiving in the market, or closer to, the common grocery store line that is around that 20% margin as well. And so again, these stores don't have the ability to make price changes. It is what is given to them by the Bureau as a price. And so they're other product categories, there's a bit more wiggle room because they can determine the retail price. And so it is a product category that of course is helpful, but they're and they certainly value having it in their storefronts. But there needs to be some increases to continue to allow these stores to sustain the other price increases that they're having to operate their business.
Thank you.
Follow up, Mr. Chair. Sorry, it's a little slow on the mute button.
You may proceed.
Thank you. No, and thank you, Ms. Cummings. I certainly very much appreciate that. Is there any way that you could get direct costs associated with actually fulfilling the liquor portion of their inventory? I know we had talked briefly, I think, a little bit about that earlier, and I'm just wondering what proportion that is. I only ask that because certainly I think this committee has experienced that liquor licenses are very extremely sought after commodities, and I'm curious to know if the business model is not attractive. What's driving that desire to have that? Whether there's more volume coming into the facilities because of that? Are there other offsetting costs? What are the benefits to that as opposed to just direct, overall general operating margins, right? So I don't know if you can get more detailed. If you can, great. If you can, I understand. I know it's a big group of associates. So, but
Yeah.
maybe just try and put it into context for us a little bit, if you could, please.
I'll certainly work to do that. And I think it will be important to show that across different size businesses. And of course, similar to, I think about my father's convenience store where he has gasoline at his storefront, knowing that that is the driver. And so I would imagine similarly, spirits serve a similar purpose. And so I'll work to get some of that information back to you all.
Thank you, Ms. Cummings. Are there any other questions from the committee at this time? So we are not taking a vote on this bill today, and I'm going to leave this discussion open. We'll pause it for next time, and at that point, before we take a vote, we will certainly hear from the department about this proposal and these asks, and then the committee will deliberate at that point in time around whether or not this will be part of the amendment or not. So if there are no other questions for Ms. Cummings at this time, thank you for being here this morning. And I would entertain a motion to table.
So moved.
It's been
Second.
moved by Representative Chiazzo, seconded by Representative Kinney. The motion is to table. It is non-debatable. The committee is ready for the question. Karen, please call the roll.
Senator Hickman.
Yay.
Senator Hickman, yay. Senator Mearmont. I can come back. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes. Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Come back. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph. Representative Dolph, absent. Representative Harrington, absent. And Senator Miramont, absent. 9 in favor of the motion and 3 members absent, Mr. Chair.
Thank you, Karen.
Mhm.
With 9 members having voted in the affirmative, the motion prevails. I will close the work session on LD 1750. I will now open the work session on LD 1906, an act regarding rulemaking and pricing under the Bureau of Alcoholic Beverages and Lottery Operations, presented by yours truly. Janet, if you would please, at your leisure, share your screen and walk us through the new amendment. While she's doing that, I can tell you that we've met twice since our last work session on this bill with stakeholders and the department. I cannot completely remember who was at the very first stakeholder group, but the department was in both. There were folks that were moving in and out, but it was the same group of folks who have been pretty much attending the entire time with few exceptions. Senator Timberlake did join that first stakeholder group. The second stakeholder group, he was not there, but the rest of the stakeholders weighed in on this new amendment. And so, Janet, if you could please walk us through, and then we'll take questions from the committee, and I could certainly invite the department in as well if people have questions for the department. Janet, the floor is yours.
This is it. Go very fast. So this amendment, I decided to use purple to show you that it's different than the last one. So you can find the correct one on your screen. So if you compare this amendment to the bill, in the bill, there was a provision, a section 1 about changing the requirements for rulemaking for labels and registration of malt liquor, wine, and hard cider or low alcohol spirits to make those rules major substantive. That's been removed. So that's no longer there. So the new section 1 is about the appeals process for the retail price of spirits. So this is the same language as you saw at the last work session. It allows the spirits supplier to appeal to the commission for an adjudicatory hearing if they are not satisfied or they're aggrieved by the decision on the retail price for their spirits product. And then after that hearing, if they're still not satisfied, then they would be able to appeal to the Superior Court, just like they can in current law. But this adds a new middle layer of an appeals process. The next piece of the amendment, it's in sections 2 and 3 on this page, replace the provisions of the bill and of the other prior amendments that talk about specific data on-premise and off-premises sales to be reported by the Bureau annually, either under the bill, either to the TTB or to this committee. And instead of requiring, as the bill and the original amendments do, that all liquor on-premise and off-premises sales be reported, this is now specific about spirits sales. So in current law, there is a requirement that the Bureau contract with a trade association that is an association of other control states for the sale of spirits, and that's NABCA. That has the contract right now, and under current law, all sales sold to on-premises licensees by reselling agents, and reselling agents are the subset of agency liquor stores that have the authority to then resell spirits products to on-premises retailers. Right now, under current law, their data on by product code, how much they sell to the on-premises retailers must be sent to this trade association and then published and made available online. And so that requirement would continue to be true to have all of that data available by product code for spirits. But in addition, this new part in section 3 of the proposed amendment would require the Bureau to also send to that same trade association information on the aggregate sales by product code of spirits products to the agency liquor stores. So that's your wholesale level data. So the spirits suppliers would now have 2 pieces of data. They would know all of the spirits that were sold by the state to agency liquor stores. And then they would also have the subset of data that they currently have, which is the amount of those spirits that are then resold by reselling agents to on-premises retailers. So they'd have 2 pieces of data here. And the bill says that this trade association has to make that data available to the spirit suppliers. The next part of the proposed amendment, as you can see, it keeps the provisions that we've talked about before about reducing the triplicate and quintuplicate. I think it was quintuplicate. It was a new word up for me anyway. Purchase order form requirements, and it specifies that when the wholesale licensee is purchasing malt liquor, wine, or low alcohol spirits from suppliers or manufacturers or out-of-state out-of-state wholesalers, that they have to submit a copy of the purchase order to the Bureau in a manner specified by the Bureau. I don't know, we can check with Senator Hickman. I believe this is because it may become an online system in the future, even though it's a paper system now. And then they would be giving copies to the people they're purchasing the order from, but you wouldn't have to fill out those triplicate forms that Ms. Timberlake had shown the committee during the hearing. This is the quintuplicate piece.
Yes.
And then the other part of the proposed amendment is to keep in the reporting requirement that you saw last time. This is different than the section 7 of the bill. So this is a provision you've seen before, but it's not the same as the bill. So it requires Bablo to submit a report to this committee about the process for establishing the retail price of spirits and all of the considerations that go into that process and why they use certain considerations and perhaps not others. And then this committee would have the opportunity to then report out legislation to the next legislature in response to that report if it feels that it needs to do so.
Thank you. Thank you, Janet. If you could stop sharing your screen at the moment, please. We may put that back up. I just wanted to see first if there were any questions from the committee for Janet on the new amendment. I have invited both Anya Trundy and Director Minio in. I know that they have an answer for the question around in a manner prescribed by the Bureau in the second to last part of the amendment. And because this language was drafted from the last meeting and is now here in front of us today, based upon what we thought we understood from the conversation, we can just check in with the department to make sure that we have interpreted the will of the consensus of that meeting with the appropriate language. So, Director Minio, please introduce yourself.
Hello, good morning again, everybody. Greg Minio, Director of the Bureau of Alcoholic Beverages and Lottery Operations. Happy to be with you discussing LD 1906. Senator, may I just answer that first question then on the manner prescribed by? Yeah, I think it's pretty much the way Janet characterized it, that we are embarking on this modernization project where the word forms will not hopefully be an issue anymore. And this effort, this initiative will eliminate all of that. And in addition to that, we are currently doing some modeling, some work now, working with removing forms, making it truly electronic. So as a precursor, if you will, to the resulting modernization effort. So that was the reason why we recommended that, to put that with language in.
Thank you, Director, and we were happy to include it. And then I just wanted to check with both you and your staff and DAFs about the way that we have interpreted the conversation around what to report and if that language captures it.
It does. The one thing that I want to point out that based on this last amendment is that there is no contract between
Okay.
the department and NABCA, which is, as it's referred to there, as a trade association. There's no contract or agreement. The state of Maine, the Bureau, is a member of NABCA, and as such, a contract or agreement is not necessary. So I wanted to point that out.
Is that language, the contract language is in statute, isn't it? I'm trying to pull up the amendment.
I think it is, yes, but again, it's something that's been just sort of accepted over the years. Many, we've been a control state for quite a while, obviously. It's just a point of reference, point of information. It can be left in. No one's ever questioned it before, but I just wanted to point it out to the committee that there is no actual contract or agreement.
So the contract is not written down, as it were. It's a mutual understanding that
Yes,
you
sir.
report this data, and this data is then made available to spirit suppliers.
That's correct. Through NABCA, correct.
Right. So I think, unless Janet has an objection, I think we can leave the language alone around that. It still technically is a contract because it's an understanding that is mutually agreed to by the people who participate in it, even if you don't actually sign it. So that's my interpretation. Not a lawyer, but I do know that agreements aren't considered contracts yet. Does anyone have any questions for the director? I saw that Anya's camera was on. I just wanted to make sure that if she wanted to add anything to this, that she's welcome to do so. Doesn't have to. Any other questions from the committee? Seeing none, do we have Representative McCray?
Thank you, Mr. Chair. I actually have a question for you as the sponsor. Could you just help me understand the rationale around section 2 and 3, the reporting? I'd just like to understand that better.
I'm going to probably ask someone to help me with that. But in the meanwhile, Janet, do you have access to the document that shows that report that we worked on, that we looked at the previous stakeholder meeting?
I will look in my folders.
So Representative McCray, if you could just wait a second. It's a visual answer more than it is something that I can just say off the top of my head. There are 4 states that present combined data in this report, and you'll see what it looks like. And then if Director Minio just wants to point out what we are asking for, it sort of puts us in alignment with most of the other control states and the way they report their data, so that all the spirit suppliers who are selling in the control states have data that they can compare across the states that's apples to apples, if you will. But I just want you to get a visual of what that looks like and how it will play itself out if we were to pass this law going forward.
I'm having difficulty finding it. I'm going to keep.
Okay. Let me see if I got it. I can't even remember who presented it to us. I believe if someone is in the attendee who has this document and is able to share it with Janet, to share with us, please raise your hand and I will promote you. And I'm going to continue to look for it as well. I might have it in an email. Someone's hands are raised, so if you just give us 1 second. I don't see Ben Gagnon. Just give us 1 second, everyone.
Ben just sent it to me again. So
Okay,
let me put it on my
Thank you,
screen.
Ben.
It's in an email. I don't usually screen share emails, but the first time for everything.
Perfect. And if you just scroll up a little bit,
It's
Janet,
not cooperating.
it's not cooperating. So Representative McCray, you can see there are 4 states, Iowa, Maine, Montana, and West Virginia, that present their data as combined reporting. And so you can see in the other states, you see the off-premise sales of spirits and you see the on-premise sales of spirits. And so we are asking for the data that we report to NABCA to be more in line with those breakouts. Now, it won't be perfect, and I think Director Minio can explain to us how this won't be a perfect apples to apples and oranges to oranges, but it is at least more information than is currently available in this report. Janet, I think that you can stop sharing your screen. I appreciate it. Director Minio.
Sorry. Okay.
Okay.
Get my hand down. Thank you. Thanks for sharing that report. I believe I mentioned in the last stakeholder meeting that that report that Sazerac provided is the result of one query, one type of query that a supplier may do to ask for when looking at any sales data for that matter, including on-premise. So in that report that you're looking at, that screenshot, Representative McCray, I believe you asked the question, that is a report that shows wholesale sales, sales from the control state to the retailer. Some states, and on that report, the way it shows, some states show the combined wholesale sales, like Maine. Some states show the on-premise and off-premise wholesale sales broken out. The reason why it's not shown that way for Maine is because the state of Maine does not sell to the on-premise sector. They sell to all the 600 plus agency liquor stores, 200 of which, thereabouts, are resellers, and they sell to the bars and restaurants, the on-premise sector. That piece of the business are considered retail sales. And those sales, just like retail sales to the consumer coming in a store, those sales are reported on what we now commonly call on-premise data, which we have had and provided through NABCA for several years. And any supplier who purchases through NABCA the sales data may go in at any time and run queries and look at the on-premise sales data and look at it 2 different ways. The supplier may see the products that are purchased by specific on-premise licensees. They may see the products that are sold by the resellers to on-premise licensees. But they can see all products, not just their own, by the way. But what they cannot see is what one particular reseller sold to one particular licensee. Because as the compromise was written in drafting this legislation years ago, it was to protect the propriety, if you will, of the resellers, because they consider that to be proprietary business information. So that's why when you look at that report as the result of a query, you don't see on-premise data because it's not, those are wholesale sales. And it would be irresponsible, it would be irrelevant to put the on-premise data in that specific report because it's apples and oranges. Now, having said all that, and thank you for listening, having said all that, every supplier who purchases on-premise data at any given time has the ability and the right to go into the NABCA system, run queries and manipulate data any which way they want. They can run it by category of product. They can look at RUMs. They can look at price categories. They can look at anything they so desire. It's all there. So, sorry, I was long-winded in my answer, but that's the reason why that report is as it is. And by the way, the other 3 states that are part of the 4 that were mentioned. I can't speak to them. I can't speak to that as far as why they only show combined as well. I wouldn't even guess, and I don't think it's responsible on my part to assume to know what they do. Thank you.
Thank you, Director. And Anya Trinity, did you want to add anything to that, or you could?
I don't think I need to add anything unless there's clarification needed.
Thank you. I just wanted to be sure. Chairman Chiazzo has a question or a comment, or both.
Thank you, Mr. Chair. So if I could kind of summarize, Director, it sounds like you're already reporting this information. So is there anything in this proposal that would require you to report differently? It sounds like you're already doing that. It's just making sure that that information is provided to NABCA. Now it's up to the end user, if you will, to put the right query in. But you're not, if I understand correctly, this amendment does not require you to do different reporting than you're not already doing now. Is that correct?
That is correct.
Okay, thank you. Thank you.
Are there any other questions or comments from the committee? If I may ask the committee members to turn on their cameras if they are here, because I don't see a quorum present. 1, 2, 3, 4, 5, 6, 7, 8. Great. So Janet, I do believe that we have a motion on the floor for this bill. It's ought to pass as amended. It was made by Chairman Chiazzo. It was seconded by Representative McCray. Although I don't remember exactly what the provisions were for the ought to pass as amended. Chairman Chiazzo.
Thank you, Mr. Chair. If it pleases the committee and the chair, I will amend my motion to accept ought to pass as amended based on this amendment that was presented this morning.
It pleases the chair. Representative McCray, will you join that in your second?
I will, second.
Thank you. So it's been moved ought to pass as amended with this final amendment that has been presented and clarified this morning. Is there any discussion of the amendment by the committee? If the committee is ready for the question, Karen, please call the roll. You are on mute, Karen. It's okay. It's Monday.
Thank you. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Mearmont. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Corey. Representative Dolph. Senator Mearmont. Senator Mearmont, absent. Representative Harrington. Representative Harrington, absent. Representative Corey. Representative Corey, absent. Representative Dolph. Representative Dolph, absent. 8 members voting in favor of the motion and 4 members absent, Mr. Chair.
Thank you, Karen. With 8 members voting in the affirmative, none in the opposition, and 4 members absent, the motion prevails. Members who are absent will have until Wednesday at noon to cast their absentee vote. And with that, I will close the work session on LD 1906. And I'm going to leave the department here because we're going into another bill. I will open the work session on LD 1643, an act to correct errors, inconsistencies, and conflicts in and to revise the state's liquor laws, presented by Senator Lupini. Janet, if you could please walk us through where we are today with these new proposed amendments. And we certainly have stakeholders who can answer questions and give their feedback on how we have interpreted the work we've done in between work sessions on the bill. Janet?
Just one second. I'm trying to call up the right file on my computer.
It's okay. It's Monday.
Okay, so my notes reflect that so far, if you look at the bill analysis, which you actually should have in blue because you picked up your binders, the only one you have in blue. You took straw votes at the last work session on the 11th on all of the technical issues, and you agreed to move all of them in just by straw vote. I would point out that for item number 14, there was a request for some a cross-reference fix there by the Bureau, and I wrote it down and you all agreed to that cross-reference fix. And then for item number 18, which was about the importation and transportation of low alcohol spirits products, you had me work with the Bureau before you took the straw vote and propose some language on that, and that is posted in the electronic committee file, that proposed language, and you by straw vote agreed to that language. So that takes care of the technical amendments. Then as far as the requests for amendments during the public hearing, the Maine Brewers Guild had a request for an amendment about fruit beers, and that would require changing the definitions of malt liquor and wine to clarify that beers to which certain types of other food additives, that's not the right word, but you know what I mean, like fruits have been added for fermentation, that those would be considered malt liquor and not wine. And at the last work session, you went through the proposed language and amended it somewhat that had been brought to you by the stakeholders. And I posted online in the electronic committee file last night an updated definition of malt liquor and wine that you all agreed by straw vote should be included. So both the amendment for technical issue 18 and then the amendment for fruit beers that you voted in favor of by straw vote at the last work session, those are both in the electronic committee file. So I think those issues so far have been taken care of. They were only straw votes though, so you can change your mind, absolutely. We discovered at the last work session that there was not really any agreement on how to fix the definitions of brewery and small brewery. The Maine Brewers Guild had pointed out correctly. I say correctly because usually it's policy stuff, but this one was my error, that the grammar of the definitions in 1643 was very confusing. I totally agree. Not as a policy matter, but just as a drafting matter. And so that had opened up a whole sort of discussion about many different things that might be implicated by the definitions there. Was contract brewing involved? Were there minimum production requirements that should be made? What about all the other authorities that breweries and small breweries had? And so it became very clear that there wasn't a resolution at that time on the definitions. And so Senator Hickman has since proposed an amendment that was sent out by email. It's posted online for this work session to those definitions to address sort of what he thinks should be done in this bill as far as those definitions. And I could go through that if you want, but that's my update.
Thank you, Jen. Are there any questions about where we are based upon Janet's excellent update? Great, seeing no questions. I am inviting Kate Knox to join us. And Janet, when she gets here, if you could put your screen onto the amendment for today that deals with the issues regarding brewery and small brewery definitions that you sent to us over the weekend or last night that is in the committee file online. And when Kate Knox joins us, I'll have her introduce herself as well, since she is the stakeholder representative that has been working with us on this language.
Do you want me to unshare for her to introduce?
Yeah, that'd be great. I don't see her yet. Let's make sure that she has gotten through the wormhole. Not quite. Let's try this one more time. Here we go. There she is. Good morning, Kate. Please.
Good morning, Senator.
And introduce yourself. Thank you.
Yes, Kate Knox. I'm from Bernstein Schurer here representing the Maine Brewers Guild.
Thank you. Now, Janet, if you could please share your screen for the committee and for the audience.
So this is the electronic committee file. As I said, that the proposed language for technical issue 18 that you approved is here. The straw vote on the definitions of malt liquor and wine is listed here. And then what we're talking about now is this Senator Hickman's proposed amendment for today's work session. It's kind of a chart, so you can probably guess I had a hand in putting it together. So the left-hand side of this chart shows you the current definitions of brewer and small brewery. One of the purposes of the Title 28 subcommittee was to change brewer to brewery. And then also another purpose was to clarify that these manufacturers have the authority to produce low alcohol spirits products. So that is sort of the background on why these two definitions appear in the bill with revisions. And as you can see, the small brewery definition right now says it brews, lagers, and kegs, bottles, or packages its own malt liquor, which is somewhat confusing grammar. So of course, that's the grammar I picked when drafting this bill to put in for both brewery and small brewery. But as the Maine Brewers Guild pointed out, that is very confusing language. One of the other things that the bill did was, if you look down later, which we'll talk about in a second, in one of the other definitions, I think it was winery, but we'll check when we get there. It talked about the manufacturer making their own product. And so that language, in an effort at uniformity, was added to all of the definitions. And that is the language that's causing some consternation between wondering, does this mean contract brewing is not allowed, or are there minimum production requirements? And I believe Senator Hickman's direction to me was to try and not get into that issue in this bill. And so I've put a star here by the person's own, because this is the current language in the bill in both brewery and small brewery. And you'll see that the definitions are rewritten on the right-hand side for Senator Hickman's proposed amendment for today. And it's going to match more closely the definition of brewery, which doesn't have confusing grammar, instead of using the small brewery confusing grammar. So it'll say that both entities can produce malt liquor by fermentation, wholly or partially, of malt or any substitute for malt. And if you remember from the fruit beer discussions, malt liquor's definition is going to explain what all of that means. And then it will also allow them to produce low alcohol spirits products consisting of malt liquor to which spirits have been added. Right now, you'll see that the proposed definition says producing or bottling. But if you look in the, I'll back up for a second. If you think of the definitions in bills I've been taught many times by the revisor's office should talk about what something is, but it shouldn't talk about what it is allowed to do. So the definition shouldn't provide authorities. And putting this bottling in here looked like the definition was allowing the brewery or the small brewery to engage in bottling. And it's not that the definition allows it, it's that the statute allows it. So 1355A is the provision of Title 28A that talks about the authority of Maine manufacturers. And for distilleries right now, it talks about their authority to bottle their products. And that's not listed for breweries and small breweries. So the proposal was, and this was discussed with some of the stakeholders before, to take out bottling from the definition and just make it clear in the statute that actually says what manufacturers are allowed to do, that they can in fact bottle their products. They're not only limiting to producing them and then leaving them in a vat, for example. I don't actually know if you brew malt liquor in a vat, so you're allowed to laugh at me if it was a completely ignorant statement. So that's what his proposal was for the brewery and small brewery definitions. But because one of the other purposes of the Title 28A subcommittee was to make things a little bit more uniform through statute, the proposal from Senator Hickman for today does similar things for the winery and distillery definitions. So again, winery is defined in current law as a facility that ferments, ages, and bottles wine and hard cider. In the bill, it would talk about the person's own wine and hard cider. So again, just like with breweries, the proposal is to take the person's own out. And then when I looked at this, I remembered that one of the other things the Title 28A subcommittee did was it emphasize that hard cider is in fact wine. It's clearly in the definition of wine. It says it includes hard cider. So there's no need to restate that here. So the proposal would be that it's a facility that ferments, ages wine. I meant to cross out including hard cider, but we can do that if you agree to that. Again, we would remove bottles from the definition because bottles would be an activity that is going to be authorized in the Maine Manufacturing Statute 1355A if you agree with this proposed amendment. Same thing with small winery. Take out the person's own and also remove bottling. So just say that it can produce so many gallons of wine that's not hard cider, and then so many barrels of wine that is hard cider. And this may look weird to you, but this is current law. This was a very highly negotiated amendment to the definition of small winery from a couple of years ago. So that's not going to be changed by 1643 unless you direct me to do so. And then as far as distilleries, again, we would take out the person's own because that is not in current law, but the rest of the definitions would be the same. And you'll note that the definitions of distillery and small distillery don't talk about bottling because the authority of distilleries and small distilleries to bottle is already in the Maine Manufacturing Statute. And that's the model that's proposed by this amendment from Senator Hickman to use for wineries and small wineries. I just remembered that I told you there was one definition in current law that talks about the person's own, and I forgot to point it out to you, and that is this definition of small winery. It does currently say that they may produce up to 50,000 gallons of their own wine, and so that's the only place where their own is going to stay if you adopt Senator Hickman's proposed amendment, because his direction to me was to make as little change as possible to current law, but just to focus on what the Title 28A subcommittee wanted to do, which was to make it clear about the low alcohol spirits products, which you don't have to clarify because all of the low alcohol spirits products that are wine are fortified wine, and therefore they're already within the definition of wine. Boy, am I getting into the weeds, I'm sorry. So you don't have to clarify it here, but you do for the other two.
Correct.
So hopefully that explains it really well. And then something else that Kate Knox pointed out this morning, she reminded me that when the stakeholders met, so the Maine Brewers Guild met with Bablo, and then I was helping with that discussion to talk about all of this issue about the definitions of brewery and small brewery. There was a concern that if you talk about the authority of a brewery or a small brewery to bottle its products, which is what's going to be added to the Maine Manufacturer Statute if you adopt this amendment, that malt liquor is not just sold in bottles, it's also sold in cans and other types of containers. And so there was a concern that if you just say that they have the authority to bottle, then you would only be able to put it in bottles. So I don't know if you have your bill out, but if you look at your bill on page 1, there's a definition of bottler, because there are some entities that you can get a license just to do the bottling. And the definition of bottler currently says it's a person that packages spirits, wine, or malt liquor for sale in containers. Well, that's what it'll read if the bill is enacted, because right now it says beer instead of malt liquor, and that's why the definition appears in the bill, because we're fixing that. So the proposal was to talk about defining the word bottle when it's used as a verb. So when you say that a brewery or a small brewery may bottle its products, what does that mean? So the proposal would be to add a definition of bottle, which would say that it means when used as a verb to package spirits, wine, or malt liquor for sale in containers. And that way you're not limiting the types of containers that can be used for malt liquor or for wine or for anything else for that matter.
And Janet, we're adding that definition to the plenary part of the law, or we're adding that definition to page 68?
It would be in the plenary part of the law.
Okay, thank you.
So it would appear right next to the definition of bottler.
Okay. And then on page 68 of the bill, we would add bottling
Yeah, if you have your bill out,
I do.
I would say look for a second at page 71, where you have distilleries and small distilleries. And if you look at 5A and 5B, so 5A says a holder of a distillery license may distill, rectify, blend, and bottle. So bottle is already there for distillery. So the proposal would be on page 68, when you're talking about breweries and small breweries. Under 3A and 3B, you say a holder of a brewery license may produce and bottle.
Yep.
And then the same for a holder of a small brewery license may produce and bottle. And the same thing would happen with wineries on page 70.
Completely understand. I see we have a few questions from the committee. First, Representative Kenny.
Thank you, Mr. Chair. I'm a little confused on the whole person's own part and why that, because I'm getting different ideas from different people. Wondering if we could have Cheryl Timberlake speak to a point on this, because she had some concerns about taking the person's own out. Just wanted to see what her take was on this, as opposed to why we're leaving it under winery. And I kind of understand, I think I understand it, but I'd like to understand better from her why she was wanted to make sure that stayed in.
I will, thank you, Representative Kenny. I will invite her in to answer your question.
Would you like me to stop screen sharing?
Please and thank you. I see that Senator Mearmont has joined us. If he would like to introduce himself at this time, that would be great.
Good morning. Dave Mearmont, representing Senate District 12, Knox County, except for the town of Washington.
Thank you, Senator. And I see that Cheryl Timberlake has joined us now as well. Please introduce yourself.
Good morning, Senator Hickman and members of the committee. My name is Cheryl Timberlake, and I'm with the Maine Beer Wine Distributors Association, a resident of Mount Vernon.
Thank you. So Representative Kenny, and I know Kate Knox is also here, has asked about the need for us, for the purposes of clarity in the law and consistency in definitions, to remove certain language that you see a little bit differently than perhaps the Brewers Guild. Can you please respond to Representative Kenny's concern?
Thank you, Senator. I will try to. Both in existing statute and in 1643 for the definition of small brewery, its own produced product are consistent in both the original statute and in 1643. Yet in the amendments that we're referring to, it's removed. And the nexus for the distributors relates specifically to another section in statute, which is our franchise protections, a very carefully crafted situation between brewery partners and distributors. And the issue there relates to what are they producing and their ability to self-distribute those products. And so when you talk about their own, that in our mind was the definition that specifically referred to products that they produced. And so when it's removed, the light starts to shine on this issue that is sensitive. And I understand it's not defined in statute of contract brewing. And so directly here, when we talk about these words and the relationships, the distributors want very much to be able to continue to work with our partners. We're trying to make sure we understand the various levels of what they produce and what they're able to self-distribute.
Thank you, Cheryl, for that. Janet, do you, well, I'll ask Kate Knox a question first. I know that this is the language that caused some consternation around this, but as Cheryl has pointed out, and as the bill analysis has pointed out, this language was already in the law to define small brewery. And so we were just changing its own to the person's own for the purposes of clarity. I guess I'm still unsure why that triggers so much consternation.
Yeah, Thank you, Mr. Chair. Kate Knox with the Brewers Guild. We have two sort of overlapping concerns. So let me first acknowledge that what Ms. Timberlake just highlighted as a concern, the Brewers Guild wants to acknowledge, and there's no intent to change that, the franchise sort of thresholds and who can self-distribute. The concern comes from this, that the existing definition saying its own malt liquor has been in there a while. But in our conversations with Bablo, they have been extremely clear with us that they want to put limits on contract brewing. And that is of great concern to the Guild. That is a larger policy conversation that quite frankly needs to happen between the Guild and Ms. Timberlake's group first, and then go to Bablo and sort of say, here's how we think the contours of this are working and what could change and not change. I am extremely concerned, not because of franchise law, but that if we leave in the phrase in small brewery, its own malt liquor, it will be a trigger for Bablo, quite frankly, who's made an indication that they may reinterpret that language to prevent contract brewing. And contract brewing is, we haven't surveyed our members recently, but it's certainly a business structure that many of our small breweries are using now to produce new lines of product for bigger breweries to cover costs of investment in canning and bottling lines. So we're very concerned that leaving that language in leaves a space for Bablo to come in over the next year and say, you can't do contract brewing anymore.
Okay.
We've agreed to start those conversations over the spring and summer, but that's where the concern comes from, Mr. Chair, and I understand it's a little bit confusing.
I think it's actually a little bit more clear where the concern comes from, but I want to ask Janet a question about a definition again, because she's been saying throughout the will analysis that definitions don't authorize activity. And so, and the director is here and Anya Trunny is here, and we can ask them directly, but I don't understand if that is the case, how they could say they're going to not authorize activity based upon a definition that's been in law for a long time, as you have suggested, Ms. Knox. So Janet, can you just talk a little bit about that? Because I know that as we worked this part of the bill, you have always said, I don't see it that way, but I understand how some do. And I'm wondering if you don't see it that way because of a definition not being able to authorize activity. Just curious.
Well, I'm not weighing in on the policy or whether that's right or wrong. I would say Title 28A is a little bit interesting in the way definitions are used. So typically, and as a matter of drafting, you're not supposed to put legal requirements in definitions, but you can explain the features of something. So you're explaining the features of what makes you a brewery. And if you look, for example, in all of the definitions about licensed establishments, which are in subsection 15 of section 2, section 2 being the definition section, there are all these different rules about what makes a restaurant versus a Class A lounge versus anything else. And those seem very substantive. And in a sense, they are, because if you then look at the licensing statutes themselves, they say that the Bureau can issue a license to an establishment that meets the definition. So then in that way, the definition kind of becomes substantive. So definitions feel very substantive, I get that. But the definition itself is not what makes it substantive for the licensed establishments. It's a fact that the later on statute says you have to meet the requirements in the definition. That's not the way 1355A is written. It doesn't say, or at least I don't recall that. Let me double check before I misspeak. If we look at page, let me find the page. It's a long section.
It is long.
It's on page 64. It says the Bureau may issue licenses under this section to breweries, et cetera, and so forth. So technically, they have to at least qualify as a brewery, so they need to produce malt liquor by fermentation if you adopt this definition. If you keep the language of, for a small brewery, that they have to brew or produce their own malt liquor, then that's part of the definition. So to be a small brewery eligible, you have to be producing your own malt liquor. So I can see that because that is the requirement in the licensing statute. But as far as, so I think it makes sense to think about it as who's eligible for a license. In that way, yes, the definitions are very substantive.
Okay.
My point for the definitions was all of the other stuff that was discussed, which wasn't about this contract brewing, but can they bottle, can they transport, can they do everything else? If you mention in the definition that a brewery is somebody who transports, that's an odd thing to do because it's 1355A that tells you what they're allowed to do when they get the license. So it's a slightly different issue, if that makes any sense.
It does. And I think my last question before I turn to Director Manuel, and I do see your hand, Representative Piazza, and I will call on you shortly unless you're talking about something completely different from this discussion. Okay, good. So we'll get to you. So then my question, Janet, is this. I'm trying to just take in all the intake and try to solve a problem without opening up a can of worms around contract brewing and minimum production requirements for small breweries. Would it be out of place in a definition to say something like, this does not mean, or this definition is intended to mean, or a person's own does not mean that they cannot engage in contract brewing? I mean, we don't even have a definition for contract brewing, so I don't know how that would work. I'm just trying to figure out a way to do both things, is to keep the language the same, but to also guard against this notion that the department may reinterpret this language to outlaw contract brewing at the administrative level. Do you understand my question, Janet?
I do. I think there's two ways, if I understand the debate, which I may not, I can think of two ways to solve it.
Okay.
To allow this bill to do no harm, as it were. If I understand Ms. Timberlake's concern, and I may not, so that's why I'm really glad she's here. The worry is about the self-distribution authority of small breweries, and that's in 1355A. And right now, it says, and if you look, it's going to be on page, just circle it, page 68. It's in 1355A 3B2. So if you're looking on page 68 of the bill, it's between lines 28 and 36. That paragraph says that the small brewery is allowed to sell its products directly to retailers. Normally, a manufacturer in Maine may not do that. It must go through the wholesale tier. But this is an authority to sell directly. And what it says in current law is that the small brewery on line 33 may sell its products directly to a resale licensee. And at one point, I thought maybe that language would be some comfort, but perhaps it isn't, because is something that's contract brewed its product or not? I don't know. So I don't know. That was one way to deal with it, is to address the issue here and maybe just leave the language here, and maybe people are fine with it, but it may not be sufficient. So the only other way I can think of, I don't think you'd put in a definition, because then you'd be trying to make substantive law in a definition. You wouldn't say this doesn't have anything to do with contract brewing, but you could put an unallocated language at the end of this bill that says nothing in this bill is intended to change the authority that anyone has under current law to engage or not to engage in contract brewing, like that the committee's not attempting to do that. Or you could even be more forceful and say that anyone engaging in contract brewing can continue to do so until the Bureau and the stakeholders meet and come up with some draft language about that. You could do something along those lines. I can't think of the correct language now because my brain is not operating on full power this morning, as you can tell from my screen sharing abilities. But I think you could try and address it that way if you just want to be clear about the do no harm or make no change aspect of the bill. I don't know if that would satisfy everybody though, but those are my off the top of my head answers.
You're muted, Senator.
I could see the director nodding. He said at some point, thank you, Representative Craig. So I'm going to call on the director to weigh in on this issue. You've heard, Director, the concern that the department might reinterpret this language to deny people's ability to do contract brewing. And Janet has offered up 2 possible suggestions to clarify that we do not want this law to address that issue at all.
Okay, thank you. I'll say up front, we have no interest in denying the activity that we commonly know as contract brewing. We will not be cracking down and doing anything different. And I'm glad Ms. Knox actually brought that up. We have no interest in doing that. We are not against it. We always just wanted it to be defined somehow. And I think the suggestion made by Ms. Knox makes a lot of sense. We've talked about this before. Let's get together and talk about it.
Yeah.
Let's, after this becomes law, let's move forward and talk about it. Let's take the summer. Let's do whatever we need to do. Let's talk about it. And I think it's a fairly complex issue. We don't have all the answers, so we look forward to talking about it. Now, as to this particular legislation, just listening right now to what Janet was saying, I like her second suggestion on using unallocated language. I think that makes sense. And if it pleases the committee, it's probably something that, that we would support. So that's what I have to say on the matter. I really think this is a big, big topic and it deserves more discussion. But when it comes to self-distribution, we also understand Ms. Timberlake's concern, but maybe the unallocated language would address that. Thank you.
Thank you, Director. So I will ask both Kate Knox and Cheryl Timberlake if the unallocated language clarifying that if we were to continue to use the language a person's own as is currently in statute, worded slightly differently, of course, with unallocated language to state explicitly that there's nothing about this particular errors bill that would stop current practice, would either of you or both of you be okay with something like that? Kate Knox?
Thank you, Mr. Chair. Am I understanding correctly that that language, its own from small brewery, would simply go to the small brewery definition? The large brewery definition would remain the same because the large brewery definition has not had that historically.
We're not, I think it is not my intention with this amendment to change current law in any way.
Okay.
So the definition that Janet wrote for 1643, Janet, can you please put that up on the screen again, today's sort of amendment? And then Senator Mearmont, do you have a comment or question about this issue? Or
I do.
Completely different, okay. So I will turn to you next.
So this, I thought you wanted to take the person's own out in the small brewery because that was the concern that was raised. But it does have its own right now. So that's where Ms. Timberlake said she preferred to keep it in.
Right.
So I think what Kate was saying, oh, sorry, Ms. Knox was saying, was to keep its own, the person's own out of brewer.
Mm-hmm.
She was asking if you wanted to put it back in to small brewery to match current law. She wasn't saying she wanted to, but she was asking if that's what you wanted to.
So
I'm watching all the heads nodding and shaking.
I am asking that question because it keeps current definition the same for small brewery. And because person's own is the phrase that causes consternation about this possibility that the department will interpret that to disallow for contract brewing. If we put person's own back in so that the definition pretty much remains the same, but we put in unallocated language to make it clear that we will not be touching the issue of contract brewing in this bill, would that be satisfactory to the Brewers Guild and to the beer and wine wholesalers? That is my question. Kate Knox.
Yes, thank you, Mr. Chair. That would be satisfactory and I think solves the immediate issue.
Cheryl Timberlake.
if I followed all the caveats, I believe if the small brewery definition keeps its own, we also very much appreciate the opportunity to continue to have a conversation with both the regulator and our brewery partners to discuss contract brewing, its definitions, and whoa, my screen just changed.
That's good that it stopped shamelessly.
Whoa. Contract brewing and its implications. We had a call prior to coming on, Senator, with a couple of guild leadership members, just to say, you know, we need to be together and we need to try to figure this out. And so we're happy to continue that conversation. I haven't seen what the unallocated language looks like, but we think it would be beneficial to everybody to set that forthwith in statute.
Thank you. Senator Mearmont.
Thank you, Mr. Chair. I guess you're getting to it, that there's no putting off. There's no, we'll talk about it later. That please do not take anything away from what any of the brewers have. And I liked your discussion the other day about, do we still need this system? And where should we be talking about getting rid of it? Which, because the answer to me is no, but it's a committee. And I don't know when we have that conversation either. A lot of people would like to just let it go and keep pushing it off and operate as usual because a lot of people are making a lot of money, but a lot of people aren't. And we really need to look at this. So, but anyway, the first point was, do not take away anything. Make sure it's clear and not left up to someone to interpret the way they feel like that day. Thank you.
Thank you, Senator. And just for everyone's clarity, we were talking about the entire system, control state, 3-tier, conversations about that. That's clearly a separate conversation that may or may not happen this session or start this session. But I had mentioned that since we're in the beginning stages of looking at another contract for 10 years, that if we're gonna have that conversation, we have to have it before we enter into another 10-year contract. So that's separate. I just wanna make sure that for the purposes of LD 1643, it is clear to the committee that if we move this into the final amendment, we will be pretty much keeping the definition of small brewery the same. So the person's own would go back in, but we would be making it clear in unallocated language that none of these changes in this bill inhibit breweries from doing what they currently already do. And everyone seems to be in agreement with that. Are there any other questions from the committee about this point? Seeing none, Representative Piazza.
Thank you, Mr. Chair. Janet, if we could go back to your, I just had a clarifying question on your amendment chart. On page 2, you were talking about in the definition of winery, in the amended language, you're saying you're striking including hard cider, but in the definition of small winery, you're making the exception, or the exception is being made that includes that is not hard cider. Where is, that seems a little contradictory to me. Can you help me understand that?
Sure, I'm very, very, very glad Kate Knox is around to help explain, and Cheryl Timberlake, because this was a very complicated bill that I try not to remember. So wine. So wine that a winery can produce includes a whole bunch of things. It includes fortified wine, which is the category of low alcohol spirits products that are wine-based. It includes sparkling wine. It includes table wine. I didn't even know that was such a thing before working on this committee. It includes a whole bunch of things. One of the things it includes is hard cider. And the definition at one point of winery was clarified so that it says and hard cider. I don't remember, I didn't trace that back when that was changed or why, but it is clear that hard cider is a type of wine, and I think that's even made more clear by 1643. Yes, on page 9 of the bill, even though inherently, if you read the definitions, hard cider is a type of wine, on page 9 of the bill, the definition of wine is amended to actually list hard cider as a type of wine so that nobody's confused about that. So then you don't need to list it separately for a winery. Now, small wineries are different because they have a maximum production amount to qualify for the small winery license, and the small winery license comes with different abilities like this limited self-distribution authority. So you have to qualify within those production caps to count as a small winery. And it used to be that small wineries, like small breweries, could only produce up to 50,000 gallons per year. But then there was this discussion between the guild and the wholesalers in the committee in a different bill about the whole wholesale licensee contract that isn't entered in between the parties. And it was decided at that time that there should be a maximum amount of wine still produced by a small winery, but depending on whether the product they're producing is wine that doesn't count as hard cider or wine that does count as hard cider, there's a different maximum cap. So because of that, you have to write the definition of small winery to distinguish between wine that is hard cider and wine that isn't, because the maximum you can ferment, I almost said brew, but that's the wrong word. The maximum you can ferment is different depending on whether it counts as hard cider. So you don't need to say it in winery because you can produce as much as you want. And it doesn't matter whether it's hard cider or not, as long as it's wine. But you do need to say it in small winery because depending on which product you're making, depends on which maximum volume cap applies for you to get the privileges of the small winery license.
Yep.
So the exclusion, if I can encapsulate that in my head, that basically would indicate that the small winery can't, do they have distribution privileges like small breweries? So that they can't distribute their own hard cider, they can distribute their own wine, but not their own hard cider, is that, no?
They can distribute their own wine. Wine includes hard cider, but what they can't do is make more than the maximum amount to qualify as a small winery. And that maximum amount differs depending on which type of product, which type of wine you're making. So if you're making wine that counts as hard cider, you can make 3,000 barrels per year and still be considered a small winery.
I gotcha.
If you're making the other type of wine, it's 50,000 gallons.
Gotcha. Okay. All right.
And that's on page 7 of the bill.
Yeah. Okay. Thank you.
If anyone else have any questions about why there's a difference in this part of statute regarding those two definitions in the person's own and the hard cider and not hard cider? Excellent. So I think that covers that portion of my amendment. Is this correct, Janet?
Yes, and depending on how the vote goes today, if it's all voted for the changes that we discussed, then I'll repost it with the corrected language, but I just have to see how people vote first. If you vote, that's up to you.
We're intending to. So are there any other outstanding issues not of substance that we need to look at to come to some consensus around before we take a final, our first vote, not final, on LD 1643?
So in the last legislature, this long chart at the beginning, some of which is shaded to show you what is technically a substantive change from current law versus what is either clarifying an ambiguity or matching current practice. So matching current practice might be viewed as substantive because the law might not match current practice, but the chart just shows you shaded anything that truly is different than either current practice or current law. In the last legislature, the committee was just fine with all of the proposals from the subcommittee and didn't go through that in detail. But I would point out that the shaded parts are substantive. I don't know if you want to go through them or if you feel like they were clearly vetted by the subcommittee. They were clearly vetted by the last legislature, so you're fine with them now and you've all had a long chance to look at them. So that would be one area of substance.
So here's, I'm sorry, go ahead. And then,
I was gonna say, and then the only other thing was the potential conflicts with other bills passed this session, which we can worry about when we see what's passed. I think the way 1906, you just voted it, is written now, it doesn't really conflict very much, if at all. I don't know about 1750. That would be the one that's sort of out there. There might need to be changes to this bill, either to take out any section addressed in 1750 or not. It just depends. I don't know what the trajectory is of that bill. And then the last thing was the low alcohol spirits products proposals from Senator Farron's bill last session.
Okay, so I can say up front that the low alcohol spirits proposals from last session will not be addressed in LG 1643, which we discussed in stakeholder meetings and in our last meeting. So before we go to the chart, maybe do first a straw vote on whether we're going to move in the amendments as discussed just this morning on LD 1643. That there is consensus amongst both stakeholder representatives and the department about these definitions. So is someone willing to make a motion to move that part of the amendment into 1643?
I would move it in.
It's been moved by Representative McCray. Is there a second?
Second.
And then seconded. So we'll do by a show of hands, all in favor of moving the amendments, the definitions as discussed this morning into the final bill amendment. Please indicate by raising your hand. It's unanimous amongst those present and voting. 1, 2, 3, 4, 5, 6, 7, 8, 9. Yeah, you got that, Jared? Great. Can you please share your screen so we can look at the chart? And I know from what your summary is, we looked at this last session. And so we really should look at it again, just to refresh our memory. Senator Farron, in the meanwhile.
I apologize. Excuse me, Mr. Chair. I like bouncing back and forth as we do. So I've been listening in one ear and catching some things. And I know where we're going forward this way, but you did mention ABV, and we did have a stakeholders meeting about that, and talked with the department about their concerns. And I just want to make sure, I'm nodding my head that we agreed that we'd take it out of 1643, but also acknowledge that we still have discussions to be had and maybe another avenue to move that discussion forward with whatever vehicle we decide upon. And I just kind of want to lay that out on the table to the committee that it's not just gone away.
It's not. And Senator Farron, just for clarity, yes, it's not gone away. And we have the authority to report out another bill this session. And so if your conversations are going to move towards some language for us to consider and have a public hearing about, by all means, get that drafted so we can get the process going.
Working on it, Mr. Chair.
Okay,
thank
great.
you.
So, and then anything else that may be addressed in that bill, contract brewing, I don't know. It's a bill that can have as much substance in it as we want, or as little substance as we want, or no substance at all. We have the authority to report that bill out and have a public hearing on it before we adjourn, sign and die for the 130th legislature. So back to 1643, Janet, if you could please put the chart up around substantive changes that may or may not be substantive, but that I want the committee to see, because the intent today is to take a vote on this comprehensive amendment. And we will deal with 1750's provisions when we get there, is what I'm going to say right now. But if the chair objects or any other member objects, we could also talk about that. Okay, Janet. Thank you.
Okay, so the first substantive change is that right now, if you have a special warehouse storage facility where you store products that you may or may not end up selling in Maine, but sometimes you just store them there and then you just sell them outside of the state. Right now, you get a license under the law for that facility, and the bill would change that to a certificate of approval.
Are there any objections from the committee about this substantive change being included in this bill? And I'm going to have to, Senator Farron, if you could lower your hand so that I can see hands who may be stating an objection. Representative Kinney.
Thank you, Mr. Chair. I'm reading this. It says it changes from a certificate to a license. But I think I heard Janet say the opposite.
Oh, you're right. I'm sorry.
So we would be making this a little bit more intrusive from current law if we force them to get a license versus the certificate.
Oh, well,
Would I be right in that?
it's a language kind of a thing. So certificates of approval are generally thought of as, I hope that the Bureau will correct me if I'm wrong, because this was a stakeholder decided thing during the 28A subcommittee process, but certificates of approval are usually thought of as authority to sell your products in Maine. And the items that are placed in these special warehouse storage facilities aren't necessarily going to be sold in Maine. If they are, then you have to take more steps when you take them out. So the idea was to not call it a certificate of approval because you might not end up selling those products in Maine. You just license the warehouse to make sure the Bureau knows about it and it's licensed. And I think that was the purpose for the change, but hopefully the Bureau can clarify if I'm wrong.
Oh, thank you, Janet. And if you could stop sharing your screen for 1 second so I can see more clearly who is here and who would like to explain this to Representative Kenny. Director Minio, I see your cameras.
Yeah, I would thank you again to the committee. Thank you, Senator. I was just reminded by my team that a COA can have a warehouse in Maine. So they'd be licensed to sell something in Maine as such. So we'd be okay with that.
You be specific, clarify what you mean when you say we would be okay with the amendment as written or not?
Yes, as written, yes.
Okay, great. Representative Kenny?
Yeah, so that would be changing it from a COA to a license.
Yes. Yes.
And Representative Kenny, do you have any objection to that now that you've understood it from the director's point of view?
I guess if the parties involved are okay with it, I don't know if there's an added cost to getting a license versus the COA. That would be my other concern, I guess, if they've been doing it this way, I guess that's where I'd be concerned, is knowing that certificates sometimes aren't as expensive as, say, a license.
Right now, the bill does not change the fee.
Okay.
And it is a statutory fee, so it's not like it's subject to change by rule.
Thank you. The next point in the chart, Janet, please, if you share your screen again, would be greatly appreciated.
Technology is getting in the way today. See, lots and lots of changes that are not really substantive. That should hopefully reassure people.
Yeah.
Okay, so the next piece, this is G on the top of page 4, but what is it, G2? I will just back up and show you that there are a number of changes that the bill makes to the requirements for on-premises retail licensees to offer food to the public for sale or to sell a specific amount of food to the public. And we did talk about this a little bit in the first session. I can't remember if it was the regular or special session, I think both, about the requirements to sell certain amounts of food. And then what the bill does is it says when you are a licensee that has these food sale requirements and you go to get your license renewed, if you didn't meet the amount requirement, so let's say you're required to sell $10,000 of food in order to maintain your license and you made $9,500, then you'd be given a 1-year grace period in which to satisfy that requirement before you wouldn't be eligible for a license renewal.
Are there any objections from the committee to that remaining included? Seeing none. Next.
The next part, there is a provision of law that allows sweepstakes games and contests to be inside packages of spirits. And right now, Maine manufacturers, wholesale licensees, and retail licensees are allowed to offer those contests inside the packages. And the bill would allow spirit suppliers also. So if you're a Maine manufacturer of spirits, you're considered a spirit supplier. But if you're an out-of-state manufacturer of spirits, you're not allowed to do these sweepstakes currently. But by saying that a spirit supplier can, you are a spirit supplier, so you'd be allowed to.
So that's everyone who sells spirits in Maine.
all the spirit suppliers are the people whose spirits are sold in Maine, yes.
That's what I meant to say.
Yeah.
Thank you. Are there any objections from the committee to this being included? Seeing none.
So we talked about this when we were talking about the definitions earlier. One of the things that the subcommittee wanted to do was to specify that distilleries, small distilleries, and rectifiers are authorized to produce low alcohol spirits, as well as breweries, small breweries, and tenant breweries being allowed to produce low alcohol spirits that contain malt liquor. So this was just clarifying who is allowed to do it. Tenant breweries, I crossed out here just because I wanted to specify, to clarify in this chart, the distinction between distilleries and rectifiers who normally produce spirits, and then all of the other kinds of entities that are main manufacturers. You'll notice here, like I mentioned a little bit earlier, wineries and small wineries aren't listed. That does not mean they're not allowed to produce wine-based low alcohol spirits products. It's just that those are considered fortified wine and they already have that authority under current law.
Thank you, Janet. Are there any objections to this being included in the final amendment? Seeing none.
The next proposed substantive change was already changed by 2019 chapter 79. So it's not really an issue in the bill. So I'm just going to skip over that one if you want. The next one is, sorry, I haven't read these in a while since I made this chart quite some time ago. Oh, okay. So currently it's not exactly clear who is allowed to pour the samples that are tested at a taste testing event, other than the law does allow people who are conducting the taste testing event to have a licensed sales representative pour the spirits, but or the wine or malt liquor, but it doesn't really limit, it doesn't really explain who is allowed. So the Title 28 subcommittee decided to say that samples for taste testing events can be can be poured by an employee of the retailer where the taste testing or sampling is occurring, or by the owner or employee of the licensed main manufacturer that produced the product. So any of those people would be allowed to do the actual pouring of the sample, or taste test, if you want to call it that.
I remember that was quite a discussion. Are there any objections from the committee to this being included in the final amendment? Seeing none. We're almost there.
Okay, so there are certain taste testing events. I think they're considered taste testing festivals, some people call them. And if you are a small distillery and you have your products available at these taste testing festivals, it wasn't clear that you're allowed to self-distribute your products to that festival. And so the 1643 would clarify that you are allowed to do that.
Thank you. Are there any objections to this being included by the committee? Seeing none.
So as far as 1355A, our favorite longest statute for Maine liquor manufacturers, there are provisions right now that talk about where you can taste test or provide samples if you are a manufacturer. And you also are allowed to have a Chapter 43 license for on-premises retail sales. And what the bill does is it provides that the area of the manufacturing facility where you are selling or offering samples does not need to be separate from and may be accessed by the same entrance as the area of the manufacturing facility that's licensed for on-premises retail sales.
Are there any objections from the committee to this being included in the final amendment? Seeing none.
So the next part, the first shaded item on page 9 of the chart, this is talking about the on-premises retail license again. So it relaxes the requirements that are applicable when a distillery or a small distillery has an on-premises retail license, because current law says that the only on-premises retail license that a distillery or small distillery can have is a Class A restaurant or a Class A restaurant lounge license. And instead, under the bill, the distillery or small distillery can obtain any type of on-premises retail license, just like other main manufacturers, as long as the same person or persons holds a majority interest in both the on-premises retail license and the manufacturer. And so again, that would just match what applies to the other types of main manufacturers. And these, that's what the second sentence says. I didn't realize that. I'm just going to repeat myself.
Are there any objections from the committee to this being included in the final amendment? Seeing none.
So paragraph H here, it newly authorizes a licensed main manufacturer that has its Chapter 43 license at a separate location to conduct sales of its products for off-premises consumption at that separate location. So right now, if you're a main manufacturer, you're allowed to sell your products for off-premises consumption at your manufacturing facility. But if you get your Chapter 43 license and it's in a separate place, you wouldn't be able to sell for off-premises consumption there. So this would be a change.
Are there any objections from the committee to this being included in the final amendment? Seeing none.
In addition, this next part talks about growlers. So it would say that if you're a brewery or a small brewery and you're, okay, if you have your Chapter 43, which is your on-premises sales location, if you have that license separate from your manufacturing facility, you wouldn't be able to sell your growlers there, and this would allow you to sell your growlers there if it's at a separate place.
Thank you. Are there any objections from the committee to this being included in the final amendment?
That is the last one, I believe.
Perfect. So since there were no objections to those somewhat substantive amendments being included in the final amendment, and since we have moved in every other part of these amendments to LD 1643, the chair will now entertain a motion to take a vote today on all that we have agreed to do. Are there any takers? Representative McCray.
I would make a motion to pass as multiply amended.
Way into the future, but I think the
Second.
council is very, very aware of.
Excuse me,
Really needs one.
this didn't work. That just came up on my other computer. I'm sorry for the interruption. It's been moved by Representative McCray to pass as amended and seconded by Representative Riley. Is that what I heard? Great. Is there any discussion from the committee on this motion? Senator Farren.
Just a quick comment, Mr. Chair, is that, as you know, I've been bouncing back and forth. So I am going to support the motion with just one small clarification that I really got to pay attention to the definitions on language review to make sure that I've got my head wrapped around them. So that's my clarification.
I appreciate it. Language review on this would be extremely important.
And I will reiterate that I will post after today, it might be late tonight, what I think everybody agreed to as the language. So that way, especially Ms. Knox and Ms. Timberlake can email me if that's not what they thought everybody agreed to.
Great. Thank you,
Mr.
Janet.
Chair, I'll be looking for that email from Janet at 10:30, 11, 11:15, whatever time it is, right?
So Representative Kenny, followed by Senator Mearmont.
Thank you, Mr. Chair. Some of this we went through kind of quick. I was just trying to reread H. These shaded ones were supposed potentially substantive changes. I'm trying to figure out if we are actually expanding the sales at an additional location, and if that's making too much of a change to statutory language. I guess I'm just a little concerned about this just slightly concerned about, I guess, on this one, is if it's an expansion of what they can do currently. And if we're making a substantive change for expanding it, it's because it's saying it newly authorizes a licensed main manufacturer that has one statutorily licensed establishment for on-premise sales to be able to conduct sales at a separate licensed location.
So let me try and explain that better,
Yeah.
because I was reading the chart that I hadn't looked at in a long time, and I might misunderstand it. So anybody in the room who knows that I'm saying it wrong will hopefully correct. So first of all, there is for the distilleries and small distilleries. So every main manufacturer, that we've generally been talking about, we're not talking about we're not talking about rectifiers or bottlers, but every other main manufacturer can have this Chapter 43 licensed location. Chapter 43 is your on-premises. So people in the vernacular would say a bar or restaurant. So you're allowed to have one of those. And if you're a distillery or a small distillery, though, you're only allowed to have two types. If you read the law literally, you can only have a Class A restaurant or a Class A restaurant lounge. So the first thing that's changed is the distillery or small distillery, like the other main manufacturers, could have any type of Chapter 43 license. Now, they're probably not going to get a tavern license because they can only sell malt liquor there, and that would not sort of be in their interests, but they could if they so chose. So that's the first change. The next two changes are about the fact that when you're a main manufacturer and you get your Chapter 43 license, it might be right at your brewery or your winery. If I can use it as an example, if it's okay, I think Kushnock has, the restaurant that people have seen in downtown Augusta that's right at the same facility, but you might have it at a separate location. So you maybe where your manufacturing facility isn't really the best place to have an on-premises sales location, so you have it somewhere else. And what the bill does is it says that if you were, my understanding from the subcommittee discussions was, if you had your on-premises location adjacent or with your manufacturing facility, you'd be able to make off-premises sales at the same place. So somebody would come to your bar or restaurant, they would really like your product that they ordered off the menu and they drank there, and then they'd want to buy some to take home. And if it was co-located with your facility, they could do that. But if it's separate, they can't under current law. So what this says is, if you're the manufacturer and you have your one Chapter 43 license, you can sell for off-premises consumption there, even if it's not co-located with your manufacturing facility. So that was one of the things it did. And then it does the same thing for growlers because they're separately listed in the law, the authority to sell growlers. So it would do that same authority for growlers. That's my understanding of what the Title 28A subcommittee discussion was about. So it is new, yes, but it was designed, they said, to match what you could do if your geography was different. If that makes sense.
It was designed, Janet, thank you for that refresher, to make it more fair across the industry to the folks who have these licenses. Director Minia, I'll ask you to let us know if you remember it the exact same way that we remember it. And if not, please let us know.
No, yes, thank you, Senator. Yes, we do. We do remember it this way. It's an expansion, if you will, a change in the law, but it's not huge, and we're fine with it.
Representative Kenny.
It's kind of funny that Janet mentioned Kushnock, because I know I've been to the location in downtown Augusta, And on my way to Augusta, I passed they have a second location, which I believe, I haven't been there yet, so I may be wrong, but I believe they're more of a tasting room type of a location. So this would expand so that they could sell there. I don't know if I've got that correct or not, but because I haven't stopped at the location that's on Route 3, I don't know if they're still in Augusta or if they're in Vassalboro by the time we get to them, but I know that I pass them every day when I come to Augusta.
Yeah, I can't
Yeah.
speak. I don't know if anybody can speak to that, but we do have some other hands up that may get you an answer to that question, and we can certainly come back to you if we get that answer more specifically. Senator Mearmont, you've been waiting patiently. Thank you.
Thank you, Mr. Chair. Just because I'm new, I have to ask this about sparkling cider, like the Martinelli's or something that it's not alcoholic, but it's in the alcohol section or near it usually. Do we handle that on this committee? Because I can't get it for some strange reason. So I wanted to figure that out. And also you talked about fruit in little bits of fruit in brews. Is that addressed under this piece as well? I remember that discussion from a week or two ago, and I can't find it, but I can't find several things here, so.
Janet?
So for the fruit beers, for lack of the so-called fruit beers issue, do you mind if I share my screen for just a second?
Please share your screen.
Senator Mearmont, I said this before you were in the meeting, I believe. If you look at the electronic committee file under LD 1643, there was a straw vote taken at the last meeting about the definitions of malt liquor and wine, but you all had worked on those definitions, so it didn't exactly match what was presented to you. You talked about changing this word here, moving this phrase there, et cetera, and so forth, and then you voted on it. So these are the definition changes that you agreed on to allow for labeling, registration, sale of beers that include some other fermentable products, and to make it clear that they're beer and not wine. Well, except if you're looking in Title 28A, we're going to call it malt liquor and not wine, because you're not supposed to use the word beer in that statute, because beer is a type of malt liquor. So that takes care of that. I have no idea about the sparkling cider you were talking about. That's a question for a different person.
Yeah, I think if there's no fermentation in sparkling cider, it would be regulated by the Department of either Ag or Health and Human Services.
Thank you.
You're welcome. Cheryl Timberlake.
And Senator Mearmont, I will be happy to make sure that we can figure out what retail licensee and get you that product. And that's an offline conversation. I apologize, but we'll assist you in that, because in our non-elk division, I know that that is a product that we carry. So we can have that conversation. In the section H, I guess we're going to just revisit that similar language, Senator, that talks about production of its products. So I will just bring that to the committee's attention as we look at the unallocated language. We can reinforce that production product and understand specifically what this extension of their license sales would include when we see that and when the stakeholders or committee get to meet and review the details. Thank you.
Thank you. Are there any other questions or comments? There is a motion on the floor, ought to pass as amended. Moved by Representative McCray, seconded by Representative Riley, on all of these technical amendments, substantive amendments, definition amendments being a part of the final amendment, finally, to LD 1643. Seeing no further discussion, is the committee ready for the question? Karen, please call the roll.
Senator Hickman.
Yay.
Senator Hickman, yay. Senator Mearmont.
Yes.
Senator Mearmont, yes. Senator Farren. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika. Yes. Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Corey. Representative Dolph. Senator Farren.
Yes.
Senator Farren, yes. Representative Harrington, absent. Representative Corey, absent. Representative Dolph, absent. 9 members in favor of the motion and 3 members absent, Mr. Chair.
Thank you. 9 members voting in favor, 3 none opposed, and 2 members absent. The motion prevails. Members who are absent will have until Wednesday at noon to cast their absentee vote. With that, I will close the work session on LD 1643 with much satisfaction.
I did just want to let you know it will take a while for that amendment review, which is why I said I'd put the definitions up, because this is a lot for the revisor's office and our office to process with such a long bill, but it won't be that I forgot about it. And that's why I do think it would be helpful to put those definition amendments up today so that, or late tonight, so that you can see them. I'll aim for 11:15 as Senator Farren suggested.
Thank you, Janet. That concludes our work sessions on the schedule for this morning. I know that we have some language reviews, and if we have time before the confirmation hearing, which will include lunch, we can take up the conversation about Russian vodka. And if we do not have time before the confirmation hearings, then we will take it up after the confirmation hearings. But Janet, can you tell us what we are going to review?
Is it possible, I'm just thinking as a courtesy to Deputy Secretary Flynn, if we talk about LD 1830 first?
Absolutely.
Because I know she's here and waiting.
That would be perfectly fine. I'm going to move her into the room to join us. And the Zoom is yours, Janet. However you'd like to do this.
That's crazy. That's dangerous. Okay, so just to remind you that we already voted on LD, well, you all, I'm not the we, voted on LD 1830, and it was the Secretary of State's bill that did several things, including talking about the timeline for when the Superior Court reviews a decision of the Secretary of State on the validity, for example, of the signatures on a people's veto petition. And there were some concerns that have arisen in the past based about making sure that the Superior Court's decision is issued in time to get the ballots printed and sent to overseas voters in time, et cetera, and so forth. So if you remember, there was language in the bill and it would have required the Superior Court to issue the decision at the latest before the 90th day before the vote. But as was discussed at the work session, there are times when the Superior Court isn't going to get the question that early, so it wouldn't necessarily make sense to put in statute a requirement that it issue the decision before it gets the case. So you all authorized me to talk to the Secretary of State's office and their legal counsel and the AG's office and work on language, but you were fine with the idea of expediting that proceeding, and then we could work on the language and how it would work out. When I went to sit down to do that, the word expedited stuck in my brain, and it reminded me that there is a joint rule that requires any legislation that's supported by a majority of the committee of jurisdiction that would call for an expedited judicial proceeding or court proceeding has to be reviewed by the Judiciary Committee. And so I put together a memo that would outline for the Judiciary Committee the language that the Secretary of State's office and the AG's office agreed on. Well, not the office, but their legal counsel acting as counsel to them agreed on for this provision. And it seemed to me that it wouldn't make sense to send that memo to the Judiciary Committee talking about your amended language when you all hadn't seen it yet. So I wanted to first show you the language, because ordinarily you just see it during language review and then you talk about it then. But we need to go to the Judiciary Committee with it. So I thought I'd show you the memo that's going to the Judiciary Committee It hasn't gone yet because I wanted you all to see the language first since you voted for it. And then you could look at that language, see if you like it, and then you now know that one of you needs to come with me to talk to the Judiciary Committee. And I won't nominate anyone, but I just need someone to come with me.
We'll make sure that you are accompanied well. Representative Piazza.
Thank you, Mr. Chair. You stole my thunder, Janet. I was hoping I actually caught you with something, but that's the February X date on there. So that makes perfect sense now. So of course, forgive me for ever questioning the intent of the document. So I didn't get to, but I was gonna try and point that out. But thank you for
It's a good thing to point out, because since I'm going to be up till 11:15 getting that memo to Senator Farron, this might not go until tomorrow, in which case it needs to be a March X.
So we've all seen it. Did you want to share your screen, Janet, again?
Yeah, I just wanted you all to hear me blabber on about it first.
It's all good. And Deputy Director Flynn is also here to comment, take questions, all of the above. Here we are.
So the memo just starts out by saying, please, review this under the Joint Rule 318, which requires you to review the appropriate priority and timing of judicial proceedings in all state courts. And then the bulk of the memo talks to the Judiciary Committee about what the issue is that you're all familiar with about the timing of these appeals and how it's possible that the Superior Court could get the question without more than 90 days existing before the election. And then the AG for the Secretary of State's office actually came up with a really good example of how that could happen, that the question could be presented to the court with less than 90 days before the election. So that example is set forth here. But what is important for you all to see, I think, the most is what the language is that was developed with the discussions between the Secretary of State's office, their legal counsel, and then me working on sort of making it fit the revisor's office standards. So as you remember, the voters can appeal decisions by the Secretary of State under the statute to the Superior Court. And under current law, it would have to issue its decision within 40 days of the date that it gets the appeal. But what this amendment will say is it has to advance the action on the docket and give it priority over other cases where the court determines the interest of justice so required. That sounds like a mouthful, and you may be wondering why I put it in there. But when Joint Rule 318 was created for the Judiciary Committee to review judicial proceedings that are required to be expedited under the law, it was decided that language like this should be standardly used. So I stuck it in there, and the Judiciary Committee can tell you, yes, we like it there, or we want it somewhere else, but this is the standard language you're supposed to use. So that was stuck in there. I'm not exactly sure where they're going to want it. But it also, the key for you all is that it says except as provided in subsection 4. So this is going to be a new subsection, which is going to explain when you don't have to, as a Superior Court, issue your decision, or when you change the timelines, because the current timeline is before 40 days after the Secretary of State's decision. And what's the difference? The difference is here, the expedited proceedings. So if the Secretary of State's decision is issued within 120 days of the election on which the question might appear on the ballot, if in fact it's determined to be valid, then these following procedures would apply. Instead of giving the person 10 days to appeal the Secretary of State's decision, that would be reduced to 5 days, as long as it was clear, there was clear notice that that 5-day deadline applied. And I did just want to remind you, because this occurred to me when I looked at this draft, as I was discussing it with the Secretary of State's office and the AG's office, is that there is a provision of current law that provides that a lot of this information is provided by email, so that it's not like it would get stuck in the mail for 5 days and you wouldn't have any notice of this decision. But I'm glad Deputy Secretary Flynn's here to confirm that. Then the next thing it would say is that the Superior Court would have to issue its decision no later than 60 days prior to the election in which the question might appear on the ballot. And in deciding it, in issuing its decision and in figuring out within its own resources how much time to take to issue that decision, the statute would direct the Superior Court to be mindful of the fact that there might be a subsequent appeal to the law court, and that all of those appeals need to be done within enough time for the question to be printed on the ballot or not to be printed on the ballot for that decision to be made. And so then under paragraph C, it also provides that if that appeal is taken to the Supreme Judicial Court, sitting as the law court, then it would have to issue its decision no later than 50 days prior to the election. And this, as Deputy Secretary Flynn can explain, is important to allow for the printing of ballots in time for the Uocava voters' ballots to go out. So this is a lot different than the language you saw. So before we send it on to the Judiciary Committee, we wanted to make sure you agreed with it.
Thank you, Janet. Director Flynn, do you want to weigh in on this? I see that Chairman Cazzo has a question first.
Thank you, Mr. Chair. And I guess, yes, it's more to, this is a question probably for Director Flynn. So would there ever be a situation where the ballot initiative wouldn't make the deadline for the ballot and it would get pushed to the next possibility? Or is the intention always to try and get it to the very next ballot opportunity?
Excuse me. The Maine Constitution requires that the decision must be made at least 60 days before the election, our decision to validate the petition. Otherwise, if it happens less than 60 days before the next election, it goes to the following statewide election, either primary or general election that occurs after that.
So this wouldn't change that. It would still have, so if that deadline was not achievable, it would just push the ballot initiative out to the next opportunity?
Well, I mean, if in the circumstance that we provided you with those dates, that would be turning it in enough time for us to make a decision more than 60 days. If they, in the normal course for the longer session, 90 days would to turn in signatures would be less than 60 days before the November election. So that would go to the following year's election, in which case there would be plenty of time to use the regular appeal dates that are in the statute. Okay. So we're talking about one that gets certified more than 60 days, certified by us more than 60 days before. But there's going to need to be an expedited schedule so that we can have ballots ready for the military and overseas voters 45 days before the election.
Okay, thank you.
Thank you. Are there any other questions for Deputy Director Flynn about this language that we will present to Judiciary Committee for their review according to the joint rules? Seeing none, unless you had something else you wanted to add, Deputy Flynn, I think we're good to take this to the next step.
I think we've made the best we can of a tricky situation. So
well, thank you for your hard work on making sure that we can comply with the Constitution as well as the law that we are trying to pass here. So with that, we will wait on that presentation and get the feedback from the Judiciary Committee throughout the process before we report this legislation out.
I would just point out, I'm not entirely sure when the Judiciary Committee will have that review. It was going to do it on Friday morning, so I was going to ask somebody to volunteer to be there Friday morning, but now they have the budget hearing Friday morning, so I'm not sure the deadline, but when I find it out, I will be picking someone, probably Senator Hickman, because he was willing to come with me if it was Friday morning. But if I can't pin him down, I'll pin someone else down. And I believe Deputy Secretary Flynn will try and be there too. It depends on when that time is, but she can help us in explaining it to the Judiciary Committee, just so you all know the process.
Thank you, Janet, for that.
So then we do have some language reviews. Do we still have time?
Yes, we do. We have time for language abuse. Like I said, we have a confirmation hearing at 1:30, so I'd like to break at 12:30 for lunch or any time before 12:30 if we feel like it. But we still have a discussion to have, which we may be able to get in before that as well. So go for it, Janet. Thank you, Deputy Planner, for being here.
Sure. So the first amendment for review is for LD 1779, which is an act to protect election integrity by regulating possession of ballots and voting machines and devices. I must have done this one late at night, like Senator Farron thinks, because my handwriting is very messy on here, so please excuse it. But you can see whether you're in the majority report or not. And this is the majority amendment. And the first thing it does is it amends section 1 of the bill to clarify that the ballot security containers that have to be remain sealed within the possession, custody, control of the clerk includes both state and municipal materials, because remember, they're in separate containers. So the language is to just clarify both types of containers have to be kept within the possession, custody, and control of the clerk. The next part was an amendment. You decided to add a requirement to the bill that the unused ballot containers also stay within the possession, custody, and control of the municipal clerk until the contents are destroyed. So that is listed here as well. That is new. It wasn't in the original bill. The next part of the proposed amendment amends 737A, which is the recount statute. And right now, the recount statute talks about transferring ballots to the Secretary of State's office for recounts of a statewide office or a congressional office. It didn't specify specifically for presidential election recounts, and that specificity is added because then the law clearly requires the transfer of these containers, and so that will authorize the municipal clerks to transfer them despite the new chain of custody requirements in the other sections of the bill. So this is because the bill says you have to have clear authority under the title to do the transfer. And then the next part of the bill states, the amendment states that when somebody is authorized to look at the ballots for purposes, for example, like the legislature can look at the ballots to decide which legislative candidate should be seated, that a public official, currently the bill states that a public official authorized by the law to inspect the ballots must be present, but there was discussion that we weren't sure who that public official was. So instead it provides, as you all agreed on the majority report, to say that the municipal clerk, Secretary of State, or the Secretary of State's designee would be supervising those inspections.
Thank you, Janet. Senator Mearmont?
Thank you, Mr. Chair. Just checking that if a box needs to be retained until its contents are destroyed, but it's an empty box, are we going to have some big quagmire at the polls or somewhere because people are just standing there scratching their heads about what to do with this thing that makes no sense?
I'm not sure if I understand the question, but maybe I can try and explain the bill a little better than I did in my
One of your first points. Okay, if you think it was just not explained clearly, go ahead. Thank you.
So the bill is amending statutes that require certain things to be sealed in containers. And once they're sealed in that container, the bill says you have to keep them as a clerk in your possession, custody, and control until the statute that governs when those contents can be destroyed, until those timelines are met and you're allowed to destroy the contents. But if the containers don't have anything in them, they wouldn't be sealed. There wouldn't be contents in them, so there wouldn't be anything to keep a chain of custody over. So I don't think it would be applied, but I could be wrong.
May I follow up?
You may.
I thought I heard part of it was that we had added empty containers to the containers that had to be retained.
I understand. Sorry.
Okay, thank you.
So the bill only talked about the containers that contained the voted ballots and incoming voting lists and different things like that, the election materials for state and municipal elections. The bill addressed those. The bill did not address the containers, the separate containers that have unused ballots. So there is something in the containers, but they're ballots that weren't used in the election. They were the extra ballots, if you will. There weren't enough people voting to use them all up. And those are in a separate container. And so there will be something in that container. It's just an unused ballot. And those containers also would have to remain sealed.
Thank you.
So you are clear on what we have done with this amendment, Senator Mearmont?
I am. Thank you.
Any other questions from anyone else? Seeing none, Janet, please report that out.
Well, that will require you all to do the signing and everything with Karen, but
yes. Thank you.
So the next one is LD 1883, which is an act to update the set-offs against lottery winnings. Again, a late night with scratchy handwriting. But this amendment, which was a unanimous amendment, retains the provisions of the bill, so you're not going to see them here, that allow access to an electronic database by the Bureau of Alcoholic Beverages and Lottery Operations. So we can have electronic access to lists of individuals who owe child support, a court fine, unemployment compensation, or state tax debts, instead of periodically receiving lists of such folks. And it also retains the provisions of the bill that allows the Bureau to immediately issue payments of winnings above and beyond the amount owed, instead of waiting for 90 days for some of those debts until a whole appeals process occurs. So if, for example, the Bureau looks and somebody owes $300 in unemployment compensation debt, but they won $1,000, they would be able to give the $700 excess right away. They wouldn't have to wait 90 days. So those parts of the bill are retained. But what the amendment does, it says that the whole process about figuring out if somebody is on a list in the electronic database of somebody who owes child support or state tax debt or unemployment compensation or a court fine and they haven't paid it, all of those requirements only apply if the person won enough money that the Bureau would be required to file a W-2G form with the IRS. And this is the way that the current statutes involving child support set-offs for casino winnings, for example, work. So that was what the amendment, what the committee unanimously decided to do. So that's why it's listed several times, is because there are several different types of debt where there are lottery set-offs. So you have to list it in each of the statutes.
Thank you. And can you scroll down, please? Is there any more?
Sure thing.
So that was it. And did we changed? I thought we tried to make something active versus passive. Is that covered in this language review?
I wonder, did I do that? Good question. Let me look, one sec.
Thank you.
I don't think that I did that. So let me fix that and bring it right back to you.
Okay,
I might be able to just email that to you if you agree.
Okay.
That was one thing I did miss because I had written it right in the bill analysis. So I forgot about it.
It's okay. It's all good. This is why we have language review, to make sure we cover everything that we discussed in our vote. So we'll await that in an email and before we report that out. Thank you, Janet.
And when I send it, I'll send it to the IP list too, so that everybody gets to see it.
Okay, that's great. Any other?
But did want to show you the fiscal part though.
Oh, please, thank you.
So there is a fiscal note required. And it says that there will be minor savings because they can do these things electronically instead of sending papers back and forth.
Great. Streamline. Reduce bureaucracy. Lovely. Are there any other questions or concerns about this before we get the final language review and email later? Seeing none. Thank you. Okay. What else do we have?
So the next one is LD 1914, And this is a majority amendment of all but 2 folks on the committee. And this is an act to allow wine retailers with 2 or more licensed facilities to freely transfer wine between approved facilities. So section 1 of the bill had some technical changes that were pointed out, or technical amendments suggested in the bill analysis. And so those technical changes are made here to section 1 of the bill. The rest, section 2 of the amendment, is very close to section, the proposed amendment that you all voted on. You had the language in front of you. There were just some minor technical changes through the revisor's office process that were made. But just to remind you, under this proposed amendment, all of the wine retailers who share the same majority owners, so those are considered commonly owned retail licensees under this language, they are allowed to pick one off-premise retail location and store cases of wine or things there that they might then transfer to their other commonly owned locations. And so the one location where it's getting approval to do the transferring and have the storage facility is considered an approved retailer here in the amendment. And then the commonly owned retail licensees are their sister stores, if you will, to which they can transfer the wine. So if you look, in order, to get the authority to transfer the wine, they must be only transferring within the same wholesaler's territory for the wine product. They must have sufficient inventory tracking system so that they could tell the Bureau at any one time where a wine product is located. And the approved facility, that the hub, if you will, from the work session discussions, can only have up to a 750 square foot space that's outside of, where products are displayed for the customers, in which they can store this wine. When it seeks the application, just as you saw before, it has to allow the Bureau to see that it's only going to transfer the wine to its sister stores within the same wholesaler's territory. It has to satisfy the Bureau about its electronic inventory tracking system. It has to satisfy the Bureau about its storage facility being only up to 750 square feet. And I shouldn't have said facility, I just meant the room in the premises where it stores the wine. It's not a separate facility. And then it also has to, in addition, satisfy the Bureau that it has a safe and secure method for doing the transportation. This language is new, but it wasn't clear the way the amendment was written, but it was clear in the discussions of the committee that there would only be one of the sister stores that gets this license. So that wasn't clear. The revisor's office pointed it out. So we added some language clarifying that. And then, as you discussed, if you want to sell more wine products or add another sister store, you would just go back and get your application amended. And then the penalties, none of that changed. And then the summary is just like it was when you saw it before. There is a fiscal note required after the fiscal review. And the fiscal note just says it's a minor cost increase for oversight by the Bureau, but that it can be absorbed within existing budgeted resources.
Thank you, Janet. Are there any questions about this language review from the committee? Seeing none, we will report this out as soon as all the, I think I've already signed for this one. So this one can be reported out. Since that wasn't unanimous, but I think we did all sign it on the last day we were here. Either way, we will get that reported out very shortly. Any other language reviews? Janet?
No. Well, no, yeah, we were going to have another one on Friday, but that's probably going to be Wednesday now.
Okay.
Because it's Sam's bill.
I'm sorry, say that again. Oh, yes. I understand. I get it. So it is 11:26. We have 2 other things that we can discuss before we break for lunch for the confirmation hearing. And since the department is here, I'm going to invite the department back into the room. so that we can have a discussion, a committee discussion, and have the department answer questions about the proposals that we have seen from both Representative Riley and Senator Miramont, requesting that all agency liquor stores in the state of Maine remove Russian spirits from the shelves. And so I will ask Senator Miramont or Representative Riley, I don't particularly care which one of you goes first, but folks can raise their hands to weigh in on this, and then we will certainly turn to the department to hear what they have to say as well. Senator Miramont, I'll start with you.
I'm sorry. I answered a phone call in that space where you're talking about what else we could do. I have no idea what you're talking about.
Well, you must pay attention a little bit better there, Senator.
I should, that's true.
Russian spirits being removed
Yes.
from agency liquor store sales. I know you have a constituent that brought that up, and Representative Riley also brought it up. So
Great. I heard that other, at least one other state, if not more, that have state-run liquor operations have been pulling that from the shelf and or prohibiting sales. Seemed to make sense since this is not. Anyway, it just seemed to make sense. I won't go into all that about the war or where that's going, but they're shutting off airspace in different countries. Maybe we'll join that too. I don't know. It's quite a good effort that's being raised without actually going into war against Russia. So it seems like it makes sense to me.
Representative Riley?
Yeah, I saw that other states, I believe Utah, Virginia, Ohio, and New Hampshire, and I think a couple others have been pursuing this. And I think while something small, I mean, it sends at least some message against Russia's invasion of Ukraine. And I think just because we have oversight alcohol in this committee, that I think any steps that we can take to push back against Russia, I think we should take.
Representative Chiazzo.
Thank you, Mr. Chair. I concur with both of my colleagues. I think if there's something that we can do that makes sense, that then we should absolutely try and do that. Obviously, statutorily might be challenged, but maybe we just do that through some kind of agreement. My concern would be, and it's not a concern, I guess it's a question for the department. Is there a way for you to designate which products are actually produced in Russia and not just a name like, I know Stoli's been thrown around, Smirnoff's been thrown around. They actually may be brewed or distilled in the States or in other countries that shouldn't be impacted. Is there a way for us to determine which products originate from Russia so that we can specifically target those and not cast a wide net over something and have an unintended consequence? So I guess it's for you, Director.
Okay, thank you. Thank you. I know I'm nodding, but I know you want to hear me say something. Good morning. Good morning.
Director Video, thank you.
Yes, thank you, Senator. Thank you, Representative. Yes, there is a way. We've identified 2 Russian-made products, actually spirit products that are made in Russia that are currently listed in Maine. One is called Russian Standard, and the other one is called Hammer and Sickle. They are currently listed for sale and available for retailers to order. So yes, we can do that. And as we all know, that there are other products that are currently listed that have Russian sounding names, like Stolichnaya, Orlov, and the like, who are not made in Russia. And they're not Russian companies per se. So there's that. So I hope that answers your question.
Follow up, Mr. Chair, if I could.
You may proceed.
So I guess my question to the department is, what are the next steps for us, right? We're not going to put a legislation in. What's the best way for us to convey our intent in a way that that we can get some discernible action out of?
Great, thank you. Great question. I'll just say this up front, that this has been a fast-moving conversation over the weekend. Anya Trundy and I and our PR communications person have been spending some time on this over the weekend, just trying to field things that are coming into us. To answer your question, though, we are working with the administration, and I think Anya can speak to this better than I can, but she and I just talked, and the administration is interested in doing something. Yes, there is interest from the administration's part to make a move on this one way or the other. Let me just go back one step though, because I think Senator Merrimont tipped off something very interesting. Talked about at least one state. We know of, I think at this point now, at least five or six control jurisdictions who are doing something to restrict and or curtail the sale of Russian-made products in those jurisdictions. I'm just going to try to remember really quickly off the top of my head, and Anya can remind me. We know of Pennsylvania, we know of Virginia, we know of Ohio, we know of Utah, and we know of New Hampshire. I think those are the five that I remember seeing. And each one of them are doing something a little differently. We just got a press release from the governor of Iowa, and they have a very similar model to what we have in Maine. I think I've mentioned that before. They're what we call wholesale states, to where they sell wholesale to their private retailers, just like we do. They have stopped making those Russian-made products available for the retailers to order. It doesn't say anything in their press release on whether they are advising or telling the private retailers to stop selling those products. There's a distinction there. So Iowa, I think, is a good example. The other one, I think, is also a good example of how they've handled it, and hopefully you've seen the press releases on it. If you haven't, we can certainly get those to you. And that's from Pennsylvania. The PLCB is the body that runs the business there. They own, remember, the retail and the wholesale. They took a good stance on it, and they're able to actually stop selling product because they own the retail. So that's where we are right now. We are working with the administration on this. Anya, did you want to add anything to that?
Yeah, sure. I think what I would add to the conversation is just that at this exact moment in time, because this is developed fast and over the weekend, what we're looking at is what is the appropriate avenue for accomplishing this. So we're looking at what Bablo's existing authority is within statute. We're talking to the AG's office and to the governor's office and trying to figure out what the actual mechanism is for it. So that's where we are at this very moment in time. There is a process for delisting products in a routine situation, and the question is what we do in kind of this extraordinary situation.
And can you, Anya, give us some ideas about what you're looking at as far as mechanisms, emergency declarations, executive orders? I mean, what are some of the tools that the administration and the Attorney General's office is looking at to implement something as soon as possible?
I think at this moment, all of those are on the table. We're looking for the thing that is the easiest and the quickest, and so we would consider all of those. I think the least amount of authority we have to exercise, the better. If we can find the existing authority, that's our preference.
Okay. Representative Kinney.
Thank you, Mr. Chair. I've been watching this as well, and I made a post on my own personal Facebook page when I saw that Governor Sununu had done this in New Hampshire, and I had people like, well, this isn't going to do anything. But every little bit does something to chip away at what's happening in the declaration of war that Russia has put onto the Ukraine. Just from some of the technical standpoints, one question that I would have for the director is how much do we actually have in stock in the state? Because we've purchased that. And and this maybe goes to Anya on this one for if we can do an executive mandate to shut down retailers in the state of Maine for a pandemic, I would think a declaration of war would warrant a similar executive order.
So Director Mineo, can you address the first part of her question?
Of course.
Okay, thank you.
Thank you, Senator. Thank you, Representative Kinney. So of the two products that I mentioned before that are currently listed, we're getting estimates right now on how many stores have distribution of the product. In other words, how many stores have ordered the product, let's say in the past 6 months. That's really the only way for us to get any type of an estimate on what may be in retail inventory. We don't have any record of, or nor do we require to know what retail inventory is in these private stores. We only know what we sell them. We think we'll have a pretty good idea of that we'll have an idea of how much is in these stores just from what these stores have ordered. I just got a text from one of my team members and he said, look at his email, and I'm going to do that right now if it's okay with the committee. I might have a little better answer. This is fast moving, as I said, right? So if it's okay, Senator, may I look at this and just
Yes. And while he's looking at that, Anya, would you like to address Representative Kinney's comment about the state of emergency?
Yes, I think this situation is a little bit different in the fact that the legislature had previously declared a state of emergency that was in effect at the beginning of the pandemic, that then allowed for the authority that was exercised via the executive orders during that period of time. So we're in a slightly different situation, but so that is part of what we're looking at.
Representative Kinney?
Yeah, well, executive orders exist at the state level and at the national level and can be done anytime, is my understanding. And it's my understanding that's what happened in New Hampshire. That was just my only comment on that. They can occur, and this just seems like the type of situation where I think you could actually unite both parties on an executive order.
Thank you, Representative Kinney. And Director?
Yes. So looking at the email from Deputy Director Poulin, I'll just read this and we can do the math together. So first of all, let me just say that Hammer and Sickle, there are no stores. We can't find one store who's ordered Hammer and Sickle in the past 6 months. So we can only assume, we can't assume, but we know that it's been basically inactive, so to speak. So I would tell me that very little of that product is in stores. Certainly there could be a few bottles hanging around from prior to 6 months ago. However, with Russian Standard, a more popular, if you will, Russian-made product, but still, in the grand scheme of things, nothing compared to some of the other vodkas. It's a very low volume, less popular item. I show, for example, in February, 21 stores ordered 4+ cases. In January, 19 stores ordered 5+ cases, and so forth. If I look at the height of this, it's December, with 44 stores in December ordering 14 cases. So that's a total of 44 stores ordering a total of 14 cases. So if you add this up over the 6 months, as many as 44 stores ordered 50 cases, 51 cases, something like that in 6 months. It's a small number, but that's what we're looking at right now.
Thank you for that information, Director. Chairman Chiazzo.
Thank you, Mr. Chair. So my question, I guess, Director Mineo, is obviously if the product is out there, I would assume we would have to work up some kind of compensation and reimbursement for the retailers if we're going to take that back. Is that how that's going to work, or are we just going to, I don't know how, because they've already paid the wholesale price to get it on the shelf. Is that correct?
Yes, they have. Yeah, they own the product. It's on their shelves or in their back room or wherever. We haven't gotten that far, Representative. Honestly, we haven't even thought about
Understood.
that.
I just want to make sure that we don't penalize our retailers in the process of doing this. So we find a way. It's small numbers. We find a way to make sure that they're made whole, at least, so that we don't penalize them as well. Right?
Got it.
Senator Mirma.
Thanks, Mr. Chair. So the economic impact isn't really significant, but the maybe a statement, I'm saying this to Ms. Trundy, that maybe it's a statement that if the governor is using the powers that she'll have to come up with, as opposed to us trying to find a way not to sell 14 cases of vodka, it's a broader statement that Maine won't accept any Russian products while this is in effect. And so because an individual economic statement's not going to be made by 14 cases of vodka. But a statement that the whole state, any product coming from Russia and any product going to Russia is going to be withheld by that emergency order or whatever outlets available to do this, would have some significant impact by joining the chorus of voices of states and countries and various different actions, such as cutting off airspaces others have done, or different things that are going on. So I guess I'm just putting that out there. Thank you.
Director Mania.
Yeah, so I just have an update to the question on retailers. I don't have to look into that, and I was reminded that we can give retailers credit, Representative Chiazzo, so that's not an issue. If we do not make something available for sale anymore, or delist it, an item, if that happens, we can certainly give them credit.
Thank you.
Any other comments from the committee around this issue? Chairman Chiazzo, did you?
Yeah, thank you. Yeah, thank you, Mr. Chair. I guess the question would be, when can the department update this committee in terms of actions that will be taken? So that I know it's a fast moving thing. I know you're working with the executive branch and other issues. Could we ask for some communication with us to keep us abreast as things happen, so that we're aware of what's going on?
Yeah, I won't speak for Anya in the commissioner's office, but yes, obviously, I think we can come up with something.
Yes.
But what we're continuing to provide the commissioner's office and the governor's office, whatever we have, Representative, we want to be sure that we're making the distinction between Russian-made and Russian-sounding products like a Stoloknoye, because that is a large-selling product, certainly, but it's not made in Russia. So we're working on it. Anya, do you want to? I'm not going to give a date, but Anya, maybe you would.
Anya Trendy, you may.
No, I don't think that I have a lot to add to that. But at the point at which we take action, we will keep the committee apprised.
Thank you.
Thank you.
That was great. We appreciate that very much. Any other comments from the committee on this urgent issue? Seeing none, thank you for participating and for being here, Department, to answer our questions, and we look forward to hearing from you. I saw a hand up in the attendee space, and I do not see it up any longer. Mr. Hackman, did you have something you wanted to add to this conversation? Let me allow you to do that. I'll just keep everyone here, and then we will close our morning session. I'll go to Senator Farron around another issue that he would like to talk to the committee about.
Sorry, I was just going to let the committee know I'm consulting with Discus on exactly what the director noted about low volume, but we did want to make sure that there's distinction made between Russian sounding versus actually Russian produced products. So happy to provide the committee. I know Discus has got data on that, and I'm happy to be a resource to the committee if that's helpful, and to the director and Tanya.
Thank you, Mr. Hackman. Any questions for him from the committee? Seeing none. Sorry, Representative Wood.
Yes, thank you, Mr. Chair. I just had a quick question, Mr. Hackman. Is part of that discussion with Discus doing, some kind of communication? Because I could see people going into a store and saying, why are you selling this Stolies? So I think personally, some kind of signage or some kind of communication to let people know that we are doing the right thing.
Yeah, I mean, we'd be happy to work with the Bureau and with others if there's something with retailers specifically, if there's communication we can have. I know that Discus, as you said, it's a fast moving situation, and they're doing their very best to try to make sure it's clear. Like Stolies explicitly was manufactured in Illinois. It's not a Russian product. So I know there's a lot going on both at the marketing level and at the industry level, but happy to partner with the Bureau and with the retailers if there's a desire to do that.
Thank you, Mr. Hackman. Representative Kinney, followed by Representative McCray.
Thank you, Mr. Chair. I agree on the Russian sounding names, and there's quite a list. And the Honorable Marge Kilkelly actually had posted an article on Facebook recently that had a list of a lot of different types of alcohols that have Russian sounding names, because they're from that general area, and a lot of the language and the writing and the spelling of some of these alcohols, these spirits do sound very Russian, but they're not. And the Stoli was one of the ones that did come up. And I know it's produced in the US, but it's also produced in Latvia, is what I understood from what I read on the article. So we're going to have to really message this very well. And I don't know, I know that there are different organizations that have their own Facebook pages. The more we can put the message out there, the better we can inform our constituents and everyone about what it is we're actually doing. And maybe we should put something out there that says that Maine only has the authority to sell 2 Russian spirits, which one hasn't been sold at all in the last 6 months, and the other one is very low volume. But we're going to do what we can to support the people of Ukraine.
Thank you, Representative. Representative McCray.
Thanks, Mr. Chair. This is sort of a ditto. I really appreciate the distinction between Russian made and Russian sounding. I think historically we know people can misunderstand, and very negative actions can happen by assumption. So I really appreciate that distinction. And it's not for this committee, but I'd be very interested generally in beyond spirits, what action we might take as a state. But that's nothing we can decide. I just make that statement. Thanks.
Thank you, Representative. Does the committee want to agree to draft a letter to the administration just outlining what we've discussed today so that they have the backing of the Committee of Oversight in whatever decision they make and when they make it? If I see thumbs up, I'd entertain a motion for that letter. And if somebody, I think Janet is certainly able to probably put on the page some of what we've discussed, but if someone wants to put in a motion what that should be, I will entertain that motion.
So moved.
Go ahead. Sorry, Representative Kenny, go ahead.
I was just so moved to put in a letter directing the department, say that we will back them in an executive order or whatever needs to be done.
Great. It's been moved by Representative Kenny, seconded
Second.
by the committee. Everyone else?
Third, fourth.
With the
fifth.
show of hands, all in favor of writing a letter? It's unanimous of those present and voting. So I'll work with Janet on that at some point today. And then we'll draft it. The chairs will sign it. We'll share it with the committee, of course, before it goes to the administration. So thank you all very much for engaging around this. It is fast moving and we're going to move fast. So one more issue before we break for lunch from Senator Farron. Thank you, Department, for being here. I will, oh, you know what? I did want to, before we stop this discussion, I just wanted to say, I see a couple of folks in the attendees that are new, and I didn't know if they were here for this or for some other reason. See Dan Davis, if you wanted to discuss this issue or not, that's on you, but I wanted to give the public an opportunity to weigh in if there were more members of the public. Okay. Seeing none, we will move on to the discussion of sports betting and LD 585. Senator Farron.
And another letter, maybe. I wanted to bring up, I talked to the chairs for the committee to have a discussion. As you know, we spent a lot of time working on LD 1352, that is on appropriations, that passed both chambers and is setting there. And I'm sure everyone's aware of LD 585, which is taking up the mobile sports betting as well. And Judiciary has heard that bill, especially with the new members that we have on this committee, understanding the complexities of betting, licenses, cascades, and all the work that's gone in over 2 legislative sessions addressing this issue. I really felt it was kind of a disservice that amendment was put on to 585 and kind of taken away from our jurisdiction. And I think as a minimum, personally, I'd like to see if the committee has an appetite to send a letter to Judiciary to at least offer our expertise and our willingness to co-hear the work session on that portion of the bill, because I really don't know. I don't know how they can do that without the work that we have done and put into it going on 4 years. So I submitted testimony, to be honest with you, to ask them to strip it and send it to us if they wanted that. I'm also very supportive of moving 1352 off the table. And I'm not trying to rock the boat. I'm trying to find at least offering the committee services to that piece. And the chairs graciously let me bring this up and see what people's thoughts and opinions on that subject are.
Thank you, Senator. Representative Kenny.
Thank you, Mr. Chair. I'll just weigh in real quick on this. I attended the National Council, I think, of game legislators from gaming states back in December. And one of the things that they brought up repeatedly was when Florida did this with the Seminole tribes. Florida's now fighting lawsuit after lawsuit after lawsuit over this, because what they did was violated treaties and violated IGRA, violated a lot of things that were in place. And we could possibly end up in a similar position based on what judiciary has done in LD 585 versus what we did with LD 1352, which included the tribes in LD 1352. And 585 eliminates the cascade. It eliminates a lot of the things that we worked so hard to protect, from our agricultural fairs to having that cascade funding come into the state, so that we can then have things available that the state can help for protections against children being involved in the gaming, from illegal betting. All those things require some funding, which would come from the way that we presented our bill versus the way this other bill is being presented, where we would, as a state, would get nothing. So I think that we do need to really look at this very closely and be very careful and watch what's happening in other states with what they have done with their tribal governments as opposed to their state governments.
Representative Chiazzo.
Thank you, Mr. Chair. Yeah, I think it's, I share a lot of the senator's concerns, or maybe concerns aren't probably the right word, probably frustrations, right? This committee worked really, really hard to try and strike that balance, I think, and I think we achieved that. And I think our success was played out with the votes that occurred on the House and the Senate floor as well. Having said that, this is the procedures, right? This is the process that we use. It's a legislative process. So I would be very supportive of us offering our input to the Judiciary Committee if they would be willing to accept that, or if they'd be willing to take us up on that. I think in the Zoom world, it would be pretty straightforward for us to do that. I also think that even in lieu of that, I think it would be very beneficial if you are concerned, or if you do want to follow that process, to read the language for 585 and be present at the work session for Judiciary, even if we're not officially there as a committee. You never know who could weigh in and ask questions, and we could be there as just as a resource for them in the waiting room if they needed something like that as well. So I agree, it would be nice to have that official request or that official offer go out, and that way we can how can I say this? We can offer our services without imposing and trying to supersede judicial's responsibility too. So I would be in favor of a letter, and in lieu of that or short of that, I think obviously participate as we see fit in the Judiciary work session. And I think we looked at that. I think it's this Thursday, if I recall, but I'll have to look again.
Yes, it is.
Thursday at 1.
Thursday at 1. Yeah.
Shannon is nodding. I think that she is the analyst for that bill. So it could be both. It could be that members of this committee show up for the work session regardless of our ability to be participants, and we can certainly offer up our expertise as a committee in the work session via a letter. So is there a motion? Senator Farron.
Make a motion that we draft a letter to send to Judiciary asking or offering our willingness to serve as a resource and participate in the work session on the gaming portion of LD 585.
Thank you. Is there a second? It's been moved and seconded. All those in favor of the committee, please show by raising your hand. 1, 2, 3, 4, 5, 6, 7, 8. It is unanimous among those present and voting. Again, we can, Senator Farron, why don't you work with Janet on that language and make sure that we can get it done as expeditiously as possible so the Judiciary Committee has it in their possession as soon as possible, whatever that may be. Senator Farron, are you willing to do that?
Absolutely.
Janet?
I just wanted you to know I'm happy to work with you both on these letters. I am in judiciary a lot of the afternoon though, so it might be a little later.
Thank you for giving us your schedule as well. Any other comments on this before we take a break? So it is 11 up. I see Representative McCray. Thank you. Sorry.
Thank you, Mr. Chair. I wanted to thank Senator Farron for bringing this forward and suggest that he discuss this with Janet, maybe 11:30 tonight.
I read emails at the strangest hours, I have to say. It's all good. So with that, it is just about noon. We are going to be at ease until 1:30 when we come back for our confirmation hearing. And we will see you all then. Enjoy your break. Just waiting a few more minutes for committee members to return from lunch, establish a quorum, and then we will be getting started with this confirmation hearing for our afternoon work.
I hate to be classed as your afternoon work.
It's all good. This is how we scheduled it. I hear there are some troubles with Zoom today. It's weird. My other committee just froze and froze and froze. So hopefully we won't have that problem here.
Oh, geez.
VLA 1, 2, 3, 4, 5, 6. Just need one more person for a quorum. So Representative Chiasso, I have a new phone. It's still a flip phone, but I have no one's number saved because it just didn't work out that way. So if you can, if you can text any other member of the committee to let them know.
I'm not even going to suggest, Senator, why you went from a flip phone to another flip phone. But again, I have the capabilities. I will start doing some reaching out.
It's actually upgraded. It's now a smartphone. It just happens to be a flip phone. So I've got the ability to do, what's that thing I don't do? Joint group texts or something. I can actually do that now, believe it or not. I'm slowly but surely coming into this handheld computer century. But
some would suggest you were better off when you couldn't do it. I mean, I just saying from a time standpoint.
Yeah.
I still have to push every letter to get the text out. So to get the word out in the text, that hasn't changed. There we are. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5. Yes, 7. I can count. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. This is a public hearing of the Joint Standing Committee on Veterans and Legal Affairs for the purpose of considering the nomination by the governor of the Honorable William J. Schneider, Esquire of Durham for reappointment to the Commission on Governmental Ethics and Election Practices. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against this nomination. This meeting is currently being live streamed on our YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel soon after the meeting has concluded. Pursuant to Title III, Section 157 of the main statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Chiasso for the purpose of making such a motion.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Veterans and Legal Affairs recommend confirmation of the Honorable William J. Schneider, Esquire of Durham for the reappointment to the Commission on Governmental Ethics and Election Practices.
Thank you, Mr. Chair. A copy of the statutory requirements for this position have been given to all of the committee members and is also posted online. The chair now recognizes Ms. Melissa O'Neill Lowe for the purpose of making a statement concerning this nomination. Good afternoon.
Hello, Senator Hickman, Representative Chiasso, and distinguished members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Melissa O'Neill Lowe, and I am the Director of Boards and Commissions for Governor Janet T. Mills. I'm here today on behalf of the governor to speak in support of the nomination for reappointment of the Honorable William J. Schneider of Durham to the Commission on Governmental Ethics and Election Practices. The Commission on Governmental Ethics and Election Practices can be found in Maine Revised Statutes under Title I, Chapter 25, Section 1002, and states that the Senate caucus leaders and the House caucus leaders shall present the governor with qualified individuals for appointment by the sitting governor. Per statute, the Honorable William J. Schneider of Durham is being renominated to seat number 2 at the recommendation of the governor and the House Republicans. Bill Schneider's qualifications for this position speak for themselves. An attorney for the last 30 plus years, Bill has served his state and country time and time again. He is no stranger to public service and brings a wide breadth of experience to this job. He holds an undergraduate degree in Weapon Systems Engineering and Computer Science from the United States Military Academy at West Point and his JD from the University of Maine School of Law. An Army veteran, Bill is also a 2-term member of the Maine House of Representatives, where in his 2nd term, he was elected by his peers to serve as the Assistant Minority Leader. He was appointed to serve on the Maine Board of Bar Overseers and served as Deputy Director and Acting Director of the Governor's Office of Policy and Management under the previous administration. Bill served as Maine's Attorney General from 2010 to 2013, and in 2014 was appointed to serve Maine yet one more time as a district court judge. William Schneider's proven leadership and diverse knowledge of Maine's legal, legislative, and election practices will bring and continue to bring great experience with a wide-reaching comprehension of issues that will come before him on this commission. It is for these reasons outlined here this afternoon that I would ask that you support the nomination for reappointment of the Honorable William J. Schneider of Durham to seat number 2 to the Commission on Governmental Ethics and Election Practices. Thank you all for your time this afternoon. I'd be happy to answer any questions that anybody may have at this time.
Thank you, Ms. O'Neill.
Senator.
Are there any questions from the committee for Ms. O'Neill at this time?
Thank you.
Thank you. The chair now recognizes the Honorable William J. Schneider, Esquire, for the purpose of making a statement concerning this nomination. Good afternoon, sir, and welcome.
Well, thank you and good afternoon, Senator Hickman, Representative Caiazzo, ranking members and members of the Veterans and Legal Affairs Committee. I'm Bill Schneider from Durham, and I'm here to ask you to recommend confirmation of my reappointment to the Commission on Governmental Ethics and Election Practices. And it occurred to me that the Veterans and Legal Affairs Committee is perfect for me because I'm a veteran and I'm an attorney acquainted with legal affairs. So this is the perfect committee for me to appear before. I've had the honor of serving on the Ethics Commission for the last 2 years, and I've been gratified by the extent to which my life and career have prepared me for this service. It began with my parents, Clayton and Phyllis Schneider of Sumner, Maine. And they gave me an excellent foundation in determining what's right, what's wrong, taking the path of the right, knowing what truthfulness brings into a life and the importance of that. They prepared me for my later career in just a wonderful, wonderful way. And they both passed now, but and I miss them greatly. I went to West Point, and that's the United States Military Academy. And our motto there was duty, honor, and country. And I'll tell you, every cadet at West Point takes that motto extremely serious, and it lives with a person through their whole career after they've graduated from West Point. And to build onto that even further, we had an honor code that required that a cadet not lie, cheat, nor steal, nor tolerate those who do. And that was a code that we lived by. And it actually, you don't realize it, I think, at the time when you're a cadet, but it provides you with a framework for the rest of your career, particularly for your service in the Army, in a way to live an honorable life. In the Army, honorable conduct is often a matter of life and death. And we received extensive training at West Point in how to apply the words and the concepts of the honor code and of the motto to our real lives. And it prepared me particularly in many ways for my later career. I went on to go to law school, and I served as a prosecutor, both a state and a federal prosecutor. State prosecutors are subject to the rules of professional conduct. Actually, all Maine state attorneys are subject to the rules of professional conduct, which set a minimum standard for your ethical conduct as an attorney. And prosecutors, I served as a prosecutor for quite a long time, have additional kind of sometimes written and sometimes unwritten rules for ethical conduct and fair play when you're involved in prosecution of criminal cases. The federal government also has additional standards of conduct that are layered onto the state rules of professional conduct. And those all federal prosecutors, federal attorneys need to become familiar with those and live by those. In fact, there's a specific office at the Department of Justice called the Office of Professional Responsibility that manages those those standards of conduct. And every federal attorney has actually frequent correspondence with the Office of Professional Responsibility to keep updated on what the ethical requirements of a federal prosecutor are. Later on, I went to serve in the Maine House of Representatives, as Missy mentioned, and I truly loved that service. I had a wonderful time being a representative in the Maine House. As you well know, there are legislative ethics rules, and those are particularly laudable and important because they're set by the legislature as rules by which to conduct their own affairs and their own business. So, to my mind, an organization that sets rules, ethical rules for itself, is many steps ahead of a lot of other organizations in society. And so I appreciated that when I was a legislator, and I appreciate that as a citizen being represented by all of you. Later on, I went to become Attorney General, and I also enjoyed that service greatly. As the leader of a department of attorneys and non-attorneys and law enforcement officers, I felt that it was my responsibility to set the highest possible example for ethical conduct. And in fact, something that I had picked up from my federal service was that the Office of Professional Responsibility operated as a resource for attorneys who could ask questions about ethical dilemmas that they faced. And so I appointed an ethics advisor in the Office of the Attorney General who would be available to all the attorneys in the office to provide advice on ethical issues that they might have encountered. And that was the first ethics advisor to be appointed in the Attorney General's office. And I'm kind of proud of that. That's a quick summary. I hope you'll vote to recommend my confirmation of my reappointment. I would like to continue my service on the Commission on Governmental Ethics and Election Practices. And I certainly appreciate your time and attention today. I'd be happy to answer any questions anybody has.
Well, thank you, sir. Thank you for your service in every facet of your career to date. The chair would ask if any member of the committee has questions of the nominee. Chairman Chiazzo.
Thank you, Mr. Chair. And I'm not sure which the appropriate title is. Is it Judge Schneider or Attorney General Schneider? I don't know what your rank was, but I will say that Senator Farron and I often have long drawn out discussions on the preferred branch of the military, but certainly I think we're lacking Army representation, sir, but you've done a great job today. So I think you are more than qualified, and I look forward to you continuing to serve the people of the state of Maine. So thank you.
Thank you very much.
Are there any other questions from the committee for the nominee, Representative McCray?
Thank you, Mr. Chair. Thank you. I'm not sure which title either.
It'll work.
Okay. I wondered, could you just talk a little bit about your process when a case comes before you and the Ethics Commission, just how you go about making your decision?
Of course. We get a wide variety of cases. A lot of them are cases that involve late filings, political campaigns, and a lot of them are involve that. Some of them are more general kind of ethical questions, and I do all the research. In fact, we had a meeting this morning. We get a very thorough packet from the staff of the Ethics Commission, and I like to read through those in their entirety and kind of use my background and my experience as a legislator, as an attorney, as a citizen of the state of Maine, to make my best judgment about the result, what the results ought to be. And I stick true to that, and that will be my vote.
Are there any other questions of the committee for the nominee? Seeing none, the chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and the residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to written comment. Karen, do we have anyone who signed up to testify in person on this nomination hearing?
I did check and I thought I saw a name. I apologize. My desk is a little bit crazy right now.
I only see one person in the audience. Is it Tracy Willett?
It wasn't that. Let me look one more time.
I think Tracy is actually from the Bureau.
I do too. Yeah.
Yeah.
Let me look. I saw.
Karen, I wouldn't worry too much about it, because if they did sign up to testify, I don't see anyone in the attendee list any longer on my screen.
I saw a Betsy Grant.
Okay.
From Hancock.
Well, I'm gonna ask for Betsy Grant to get a Zoom link to come and testify if she is here. But if not, going once, going twice. All public comments having been taken, the committee will now proceed as follows. Review any additional written comments on the nomination that have been received by the committee. Vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 35 days from the date of the governor's written notice. The hearing by the Joint Standing Committee on Veterans and Legal Affairs for the Honorable William J. Schneider, Esquire of Durham, for reappointment to the Commission on Governmental Ethics and Election Practices is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire whether any member present objects to proceeding to take the vote immediately. Seeing no objection, the pending question before the committee is that the Joint Standing Committee on Veterans and Legal Affairs recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable William J. Schneider, Esquire of Durham, for reappointment to the Commission on Governmental Ethics and Election Practices be confirmed. In accordance with 3 MRSA, Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? The committee clerk will call the roll.
Senator Hickman.
Yay.
Senator Hickman, yay. Senator Mearmont.
Yay.
Senator Mearmont, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yay.
Representative Kinney, yay. Representative Harrington. Representative Harrington, absent. Representative Corey. Representative Corey, absent. Representative Dolph. Representative Dolph, absent. 9 having voted in favor of the motion and 3 members absent, Mr. Chair.
Thank you. 9 members of the committee having voted in the affirmative, 0 in the negative, and 3 members absent. It is the vote of the Joint Standing Committee on Veterans and Legal Affairs that the nomination of the Honorable William J. Schneider, Esquire of Durham, for reappointment to the Commission on Governmental Ethics and Election Practices be confirmed. Congratulations.
Thank you very much. I really appreciate your help.
And we appreciate you continuing to serve.
It's my pleasure.
Have a great day.
Thank you all.
Thank you.
Congratulations, Bill.
Thank you, Missy. I appreciate it. Thank you for your help too.
Welcome.
Senator Mearmont.
Before you move on to other business, could I record my vote for a vote this morning?
You can tell Karen to vote from this morning, yes.
On 1906, I vote yes.
I will record you as in favor of the motion then, Senator Mearmont.
Thank you very much.
You're
Thank
welcome.
you, Senator. Well, we have no other business for today unless there's something I missed. Anyone want to bring up another discussion to write a letter about? All right. So the Joint Standing Committee on Veterans and Senator Farren, here we go.
No, I apologize.
It's okay.
I do want to ask a question for Wednesday's schedule. I understand that one of the bills that we may be hearing for public hearing has to do with the closing of the Caribou and Machias veterans homes. And I just want to say, I believe that we've been asked, or the chairs have been asked, to waive the public hearing notice on that. And I just want to say that I think something that is dramatic as closing veterans homes in Machias and Caribou deserves the proper public hearing notice and a chance for the public to weigh in on that. And I don't know if that ship has already sailed, but just wanted to kind of go on record saying that I have a concern with that.
Thank you, Senator Farren. The presiding officers waived notice because the issue is impending, meaning that if we were to take action to stop the closure of either or both veterans' homes, the decision of the legislature to do such a thing would need to happen as an emergency to an emergency. And that is why both presiding officers waived the notice for the public hearing. Now, with that said, Karen, can you tell us if in fact you have been instructed to put that public hearing into the system for 2 o'clock on Wednesday afternoon?
Right. It is in the system for 2 o'clock, and now I will send out the notices. There were some LEAP issues this morning. So, yes.
There were issues, it seems, across the technology. So for anyone listening and for Senator Farren's consideration, The public notice is right now, and the meeting will be at 2 o'clock this Wednesday. And it is because it is an emergency on top of an emergency. And so that's why both presiding officers waived notice for this public hearing. This is the only public hearing that they have waived notice for at this point in time.
And I'll just say, Senator Hickman, is that I have reached out to the American Legion and a bunch of other veterans organizations, and I talked with the House Chair this morning. We're going to reconvene after the public hearing. We're going to reconvene the Veterans Caucus to get some input as well. And unfortunately, in the times that we're living in right now, I heard about it on Wednesday from a Facebook post before we even knew that it was going on. So the communication piece, with that is sometimes difficult.
I think that because this is happening so expeditiously, whenever the work session is, we will certainly involve or invite as much public comment at the work session, sort of out of order of the normal rules of a work session, precisely because this notice was waived in advance. So it's not going to solve the problem that you just brought up, but it is what it is. And so we intend to invite as much public comment on this as possible before the committee takes any action on the bill. Okay.
Thank you.
I appreciate you bringing it up, however, so that now the public has at least heard from the committee that this will be happening on Wednesday at 2, and we will go from there. Anything else? Any other questions, concerns? All right, that's it. The Joint Standing Committee stands adjourned until Wednesday at 9 o'clock.
Bye-bye. Thank you.
Have a great day.